Good morning, honorable members.
Morning, Chair, colleagues.
Morning, Chair, colleagues.
Okay, now you can hear me. You can hear me. It's always a sound check. Good morning and thank you. And thank you very much for joining today. So we continue to process our RAF report. We close to the end.
And you're welcome, Chair.
Honorable Skosan, how are you? We close to the end, but I'd like to, apart from processing this section of the report today, I'd also like to alert you to an email that would have just arrived, or if it hasn't arrived, it's coming in the next few minutes. It's a letter from the speaker. If you recall, we had sought her concurrence on our resolution to press to lay a charge against a former chief executive of the Road Accident Fund. So she's taken a legal advice and has written a letter to the committee. So we will table that letter. And I know that I'm springing a surprise on you, Ms. Ibrahim, but I would like you to take us through that letter at the end, once we've completed this part of the report. Then we discuss the letter, and then we can then see what we do thereafter in light of its comments. So I will just leave it at that, but it should be in your emails. I will just ask our chief executives, Ndombi, to also put it on the WhatsApp group for those members who may just be challenged getting to their emails in case you are in transit, so on. So if we can do that. Otherwise, Ms. Ibrahim, good morning. I hope that you are ready to do the usual. And if you are, I would like to ask you once again for you to just help us go through this section of the report.
Thank you. Good morning, Chairperson, to all the members and staff on the platform as well. The section that we're dealing with today is on the medico-legal service providers and issues specifically related to the panel of medico-legal experts. This section is a little bit shorter than the previous sections. So medical-legal experts obviously play a central role in the RAF ecosystem. They produce reports, and those reports get produced from people ranging from your general practitioners to your specialists, doctors, also occupational therapists, and so on. And the purpose of those reports essentially is to assist the RAF in validating and quantifying claims for injuries and loss of earnings. So it's necessary that those reports are reliable, that they're accurate, and that they're timely, so that the RAF in turn can then compensate people fairly and speedily. So I just want to distinguish before we continue that these medical experts are not the medical service providers that provide medical care to patients. So in other words, when you're involved in an accident and a doctor performs surgery, or you're under the care of a particular doctor, that is not the doctor that we're referring to here, or the expert that we're referring to. These are experts specifically used to assess a patient and then provide that independent information to the RAF to assist it in quantifying a claim. So historically, the RAF has always procured its own experts to assist it with the assessment of claims. So these people are not based in-house.
Sorry, Ms. Ibrahim.
Yes, Chair?
Just a sec. So I see Honorable Skosana's hand is up.
I just wanted to ask, in fact, when I read the report, to say, when you say expert, perhaps a better word would have been consultant. But anyway, it's semantics. Thank you, Chair. Because expect to me sounded like, yeah.
All right. No, thanks, Honorable Skosana.
Thank you, Chair. It's noted. The reason that we referred to experts is because that is the manner in which the RAF refers to these persons. So all the tenders, for example, refer to procurement of experts, and generally in the industry, they're known as experts. That's how you would distinguish them from the other medical service providers, for example, the doctors that were part of the Sunshine group. So the RAF historically has procured experts to assist with this assessment of claims, but claimants themselves can also submit their own medical reports, and they then in turn may procure the services of experts also to provide expert testimony, for example, in court proceedings. If a claimant utilizes the services of an attorney to process their claims, then typically the attorney would procure the services of an expert on behalf of the claimant to defend that claim. So often what you would find in a court setting is that the RAF would have its own expert reports, and the person who's claiming would also have their own expert reports, and the judge would then have the benefit of both reports in determining that compensation. So during our public participation process, we received several submissions from experts, and that would have been both experts that were procured by the RAF as well as those procured by attorneys. So two very distinct groups. In the one group, it's experts performing work for the RAF and for the benefit of the RAF, and they did that either because they were procured directly by the RAF or via the RAF's panel of attorneys. In either cases, the issue then remained that they were not being paid. Either the RAF was not paying them directly or the panel of attorneys was not paying them, and that was the unhappiness that they wrote to the committee about. We then also heard from experts who were performing work on behalf of a claimant on instruction of that claimant's attorneys. So in other words, that has nothing to do with the RAF. That is an attorney acting for a claimant who then utilizes the services of an expert. So in the former example, that falls squarely within the mandate of the committee, because that concerns non-payment by the RAF. The latter example, however, is obviously a private contractual issue between those attorneys and experts, but we do deal with it to some degree later in the report, and I'll explain the reasons why. So in terms of evidence, the committee received a submission from Ms. Minnie, who we invited to testify before us. And members will recall that she's the owner of a close corporation called MMB Easy, which processes accounts on behalf of experts and who provide services to the RAF. So she handles that payment administration process on behalf of these experts. And the reason that we decided to call Ms. Minnie as opposed to individual experts, because we had submissions from quite a number of experts, was that she had provided services to more than 100 clients over an extended period of time since 2007. And she also had a plethora of information in the form of records at her disposal, which she was willing to share with the committee. She's also been quite vocal on the issue. If members Google her name, you'll see that she has a long history of reporting on these sorts of issues, and she's worked quite intimately with the RAF. So that was the initial rationale, to call one person to set the scene for us rather than calling individual doctors. Obviously, there's also a concern that where you call individual experts, that you may go into personal information in the respect of particular individuals, which we didn't want to take that risk as well. So Ms. Minnie, as I indicated, has been doing this work since 2007, and she indicated that from that point, they were definitely using a dedicated panel of experts to do services on behalf of the RAF. And she said that these experts, which were on her books, would have received their instruction briefs via an attorney appointed to the RAF's panel of attorneys. So each panel of attorneys would deal with selected case files, and if in a particular case file you needed a GP report, or you needed a report of some other specialist, then that attorney would then procure that on behalf of the RAF. And she indicated that notwithstanding that they were procured by the RAF, the POA managed the services as part of that case management. So, i.e. notwithstanding that the RAF was actually ultimately paying for the services. And these experts would be responsible for submitting written medico-legal opinions, and if the matter had to proceed to court, they would testify as expert witnesses to defend the content of those opinions. So it's quite an important role, because it's what ensures that the ultimate amount that is paid to a claimant is a fair amount, and that the RAF is not paying more than what it should. So ensuring that, for example, injuries or the extent of injuries is not inflated in claims. So although the experts were procured technically by the RAF. In Ms. Minnie's experience, the manner in which they submitted the invoices and in which they were paid varied. According to her, some experts would submit the invoices to the instructing attorney for onward submission to the RAF, whilst others would submit to the RAF directly. So payment would either therefore be made by the RAF to the medical expert without a third party involved, or to the attorney for onward payment to the expert. And in both of those cases, there would still be an attorney involved. And she had indicated that, she couldn't explain what the reason was for the way in which this was treated differently. In mid-2015, a new expert panel was put in place for a period of 3 years. That would have been from 2015 to 2018, following an open bid process that had commenced in 2013. And so members can see here how long it seems to take for these bid processes to unfold. So it commenced in 2013, the panel only gets appointed in 2015. And successful bidders were provided with service level agreements, which were concluded based on the RAF's tariff for expert fees at the time. So they have a tariff saying that they will pay particular experts a particular amount. The RAF, according to her, published the list containing the names and the designations of the experts appointed to that 2015 panel. But since the 2015 panel, it was her submission that no such list was ever published in respect of later panels. And she explained to the committee that meant that for the intervening period, it was not possible for a third party to ascertain whether an expert had been lawfully contracted by the RAF. We do note, however, that from our own desktop research, we were able to access a copy of service providers in respect of the 2021 panel, which I found on the RAF website following Ms. Minnie's testimony. And it was presented to her, and we did ask her for comment, and she indicated that to the best of her knowledge, that definitely wasn't on the website prior. She had sent some screenshots. She also sent a copy of an email between herself and a medical expert to prove that medical expert was only informed in June 2022 that she was on the panel. And that was to illustrate that there definitely wasn't a list prior thereto. Otherwise, experts would have known if they would have been successful in that tender process. So she maintains that as recently as last year, the list was not published. So at the time when she had started her consultations with us. She further testified that notwithstanding that there was a procurement process that was followed to appoint this 2015 panel, and that this list of experts was published in 2015, the RAF ended up using experts that were not on that 2015 panel because that panel was unable to fully service the needs of the RAF, or services were required of specific types of experts that did not appear on that list. So she indicated that there were only 82 experts for the entire country, which we've checked. And for example, there were only 2 orthopedic surgeons listed for the entire country. And according to her, the reason that some experts would not have bothered contracting with the RAF was because those tariffs that the RAF was willing to pay were not necessarily market related. But the RAF soon realized that this 2015 panel was not sufficient, and it then allowed panel of attorneys to use experts not on the panel, with the proviso that they should attempt to contract services within the tariff. But they were not bound to do so, and she did provide proof of that. She further testified that after the expiry of the 2015 panel, which would have been 3 years later in 2018, there was no panel in place for a period of time, and the RAF then issued an interim directive which allowed attorneys to appoint any expert subject to prior approval by the RAF. So the attorney would procure the services of the expert on behalf of the RAF. And she noted that some of these experts were obviously not contracted in respect of the RAF tariff, so they charged higher rates. And she raised the fact that to her this called into question the adequacy of the RAF's procurement processes. Because now you're allowing attorneys, notwithstanding that they needed to get approval from the RAF, but you're allowing them to contract out of those tariffs. On 27 July 2018, so we've now had the 2015 panel expire and a new process must be commenced with. But instead of issuing a tender, what the RAF did was to issue what is known as an RFI, a request for information. So typically in government, we understand an RFI to simply be that, as it states, a request for information. So in other words, not a formal tender process. If one were to go on the National Treasury website, you will find quite a number of documents that explain what an RFI is. And I've quoted from one of them where National Treasury describes an RFI as something that is generally used when the solution to a business problem is not immediately evident or clearly defined. So in other words, it's an information gathering tool, and it's not used to make a selection or award. So the purpose ought to have been to allow the RAF to obtain information, for example, on pricing and service offerings, so that you can design a fit-for-purpose bid. So you go to market and you say, what is it that you can offer? What would you charge? And that then gives you an idea of what would be market related, so that you can adjust those tariffs as necessary, and also so that you know what is available. So it would give you a sense of, for example, how many of a particular type of expert there is. Is there a reason that there were only 2 orthopedic surgeons that responded the last time? Are these surgeons available in every province? And so on and so forth. And the whole point is that you can then design your bid. But according to Ms. Minnie, that RFI process was not followed by a tender process until some years later in 2021. Where the RAF sought to appoint experts then for a period of 3 years until 2024. So on her evidence, there's a gap of approximately 3.5 years in terms of which there's no tender process. There is only this RFI process. And members may recall that we had heard from Mr. John Modise, who was the former senior manager for procurement at the RAF. And he provided the committee with some insight into what happened in that intervening period between the RFI and the establishment of the 2021 panel. And important information that he gave us was that the panel of experts, the estimated cost there exceeded R1 billion a year. And his evidence suggests, though, that the RAF viewed the RFI process as a tender process, and that they had the support of National Treasury for same. We, to the best of my knowledge, don't have records that indicate that National Treasury would have viewed that RFI process as a tender process. But he explained that doctors typically were not interested in responding to bids. Completing bid documents can be quite cumbersome, providing proposals and so on. And this created the difficulties that the RAF was facing in terms of getting the necessary experts onto the panel. And according to him, National Treasury advised them to initiate a request of expression of interest, which they then published in the media to say that any medical professional that is interested in participating or assisting the RAF can then log onto a portal and load their details. And based on that, then they would be made to sign service level agreements, which they would then download from that portal directly. So it wouldn't have followed the ordinary way in which a bid would have unfolded. And, they would have had certain checks and balances, for example, to make sure that these experts were not blacklisted and that they were then loaded onto the central supplier database. He explained that the 2018 process had quite a bit of practical difficulties. And due to the value of the contracts there, which exceeded 20 million in total across the expert panel as a whole, the delegations of authority, obviously, as I said, it was almost R1 billion that they would be spending a year. But in terms of their delegation of authority, where you're spending more than 20 million, you would require board approval for purposes of signing SLAs. So he says that when people submitted responses to this RFI process, they then required the board to sign off on SLAs that would be provided to these experts that had logged onto the system and downloaded copies of these SLAs. And he says that in November 2018, the SCM department sought approval from the board to delegate that job to a group of executives including the Chief Operating Officer and the General Manager of Legal and Medical, because this would obviously allow the process to be streamlined, and you would split the intense practical work of actually signing all of these contracts amongst various people instead of expecting the board to physically sign off on all of these contracts. However, the board did not accept that request. What they did authorize instead was that the acting chief executive officer at the time, Ms. Jabavu, was authorized to sign the contracts with experts. And the authorization did not confer on her any power then to subdelegate, meaning that she physically then became responsible for signing all of these contracts that emanated from this RFI process. And this obviously caused a delay in signing contracts, and it resulted in some experts then refusing to do work, according to Ms. Minnie, with the RAF in the absence of an SLA, because typically the SLA is what is going to give you some legal protection. According to Mr. Modise, though, by the time that Mr. Letswalo assumed the role of acting CEO in September 2019, there was still quite a number of outstanding SLAs that needed to be signed, and this culminated in him sending an email in February 2020, so the following year, where he instructed Ms. Jabavu in her capacity then as Chief Operating Officer to sign all of the contracts, and indicated that this should be finalized by the end of business tomorrow, so on the 15th of February. And we know from the information provided to us by Ms. Minnie that Mr. Letswalo was under some pressure from experts during that period to sort out the mess with the SLAs. And Mr. Modise then said SCM was not engaged, and they found themselves in a difficult position because they were of the view that the delegation that he purported to give to Ms. Jabavu would not have been valid because he didn't have the power to delegate further. So the board had given the power to the CEO, and there was no power to subdelegate. So that was a serious concern that SCM had. And Mr. Modise then responded via email to Mr. Letswalo that for audit purposes, the board should be engaged to rescind the previous resolution to delegate and then to delegate that signing power appropriately. In other words, to allow Mr. Letswalo then to subdelegate. However, according to Mr. Modise, it appeared that Mr. Letswalo had taken umbrage, and he responded within a few short minutes. And his position was that the COO has full knowledge of the contracts, and it makes sense that he delegates to her to sign, given that she must apply her mind, of course. And in his affidavit, he then goes on to explain how he agonized over what to do because of this email that he had received, and he eventually capitulates and he agrees that there's no written provision anywhere that provides that the CEO is not empowered to delegate powers further. So notwithstanding that it is really a common law principle that you cannot subdelegate unless you expressly authorized to do so. And he then went on to explain that in his view, that incident resulted in his retaliatory suspension. Ms. Minnie, on the other hand, stated that some of the experts in her book didn't receive an SLA at all, despite responding to that 2018 RFI. And then others who hadn't even responded at all to the RFI were given work nonetheless. So in her words, it was therefore never clear how the RAF procured and established this panel of medical experts. And her evidence was that the contracting process in respect of that 2021 panel was also chaotic and confusing. So we had all these SLAs that had to be signed. And she notes that the panel was approved by the board on 31 March 2022, but in fact, experts had received SLAs for signing prior thereto. And she provides the committee with documentary evidence in the form of emails that she wrote to the RAF between December 2021 and February 2022, where she highlighted various discrepancies in the SLAs. And some of those examples were that experts by this time had already received 3 different versions of SLAs that they should sign. So they would get a version, they would sign it, then they would be told that version is incorrect, there's further changes that have been made, they need to sign another one, and this happened 3 times. There were portions of the SLA that were blank. The pricing schedule was based on the 2018 tariff rather than the 2019 tariff. The pricing schedule included VAT, whereas not all experts were VAT vendors. The starting date of the contract was 14 December 2018, yet obviously related to the 2021 process, because by then that period had already expired. It made reference to persons who were no longer in the employ of the RAF, and it still referred to the panel of attorneys, which by this stage was not even in existence. So that is just really a small portion of some of the issues that medical experts would have faced with contracting. Then in respect of payment, it seems to be historically that payments were always slow, that experts always face payment challenges regardless of who would have instructed them, i.e. whether it was via attorneys or the RAF itself. And by 2018, there was a formal complaint lodged with the RAF by more than 200 experts regarding non-payment of invoices and also a lack of clarity on payment procedures. And the fund at the time did undertake to deal with unpaid invoices, but the problem seemed to persist. So definitely this was a historical issue that the RAF faced. Matters were obviously exacerbated by this abrupt termination of the panel of attorneys in June 2020. Which particularly has a severe adverse impact on experts who had been procured via the attorneys and who had submitted their reports to these attorneys. So as I mentioned, you have an attorney dealing with a file of a claimant, and that attorney is giving instructions to the medical experts. That attorney is making arrangements for the medical experts to engage with the client and so on. And now suddenly that panel then gets cancelled, and you now have experts sitting in limbo because they've done work already, but they're not sure who to now deal with going forward. There was a directive that the RAF issued on 2 March 2020, which was in fact 3 months prior to the dissolution of the panel of attorneys, where they then get directed to send their expert reports directly to the RAF. So obviously the RAF at that point was aware of the fact that it was going to cancel the panel of attorneys. If not, it wouldn't have been necessary to send out that directive. But according to Ms. Mini, there was no concrete plan in place for experts then to engage directly with the RAF and to receive full and timely information that may be necessary to provide accurate medico-legal reports and opinions. So it then fell on these experts to find out who the claim handler was in respect of particular files, try and contact that person, and of course, that's not always possible. So the problem that you then sit with is that experts need information to compile their reports. That information ordinarily they would have gotten directly from the attorneys, but they're not able to get that from the RAF because they don't have a dedicated person that they could contact in that regard. In any event, if one has to just think about the number of claimants that there would have been, it would have been impossible for 1 or 2 people at the RAF to immediately be able to provide all of that information. And experts obviously need information in order to compile their reports. So often they rely on other medical reports to compile their own reports. They need information relating, for example, to the person's employment, what their job entails, and so on. And in the absence of that, they're not able then to put together their report. Now you don't have a panel of attorneys in place at all. And so the RAF is now instructing experts directly when it does require expert services, but they expect experts then to wait for a VRS number, which is a vendor rotation system number, which basically confirms their instructions. But according to experts, and this was repeated not just by Mini, in fact, much of what Ms. Mini provided the committee with was also reinforced by other public submissions that we had received, that patients would then arrive for their appointments, but the VRS number hadn't been issued. And so experts then would end up turning patients away because they obviously don't want to take the risk of non-payment. In addition, you still had the fact that this was only in respect of new matters. In respect of older matters, then you still had the fact that experts had monies that were owing to them in respect of work that they had done under the guidance of the panel of attorneys, but for which they hadn't been paid. And on 1 June 2020, interestingly, the very same day that the panel of attorneys was cancelled, Mr. Letswalo held a meeting with experts, and he acknowledged that there's this debt owed to them, and he undertook to approach National Treasury for guidance pertaining to payments due to experts who were contracted by the panel of attorneys. So clearly that the RAF was aware of the fact that if the panel of attorneys is going to be cancelled, it's going to have practical repercussions on medical experts in particular. So these undertakings were made. They also said that they would facilitate meetings with the experts in each province. They would resolve on a process for submitting invoices in terms of an agreed plan and time frame. And that they were also rolling out this ICMS system, and that system would then magically fix everything, because the system would then allow experts to lodge their claims for payment, for them to be able to get information that they required, and so on. So that they were given assurances that this new system would give them access to all the patient information they needed, the medico-legal reports of other experts, and so on, to assist them. Obviously, we know that that hasn't been done in terms of that ICMS to date, notwithstanding that it was 2020 already when those undertakings were made. Mr. Letswalo met with the experts again in August 2020, and he indicated that they had engaged with National Treasury, and National Treasury had given agreement that they could pay experts directly, but he was waiting for something formal in writing from National Treasury to give the RAF the go-ahead. And in August 2020, the same month, a few days later, the RAF requests experts to resubmit their invoices and supporting data for due diligence and reconciliation. So obviously, experts would have been under the impression that everything is good to go at this point. National Treasury has given the nod to go ahead, and therefore they've been asked for this information. Ms. Minnie did say that, it was always the case that experts were made to repeatedly resubmit their invoices, and they appeared to have no reliable systems in place to manage invoices. And she said, according to her, there was no proper filing system. And, you would find if you went to the RAF offices that there would be thousands of invoices strewn on office floors. And she explains in her affidavit that, for example, she would have to go on her hands and knees to actually look for invoices. However, despite all of these acknowledgements and promises, this issue of non-payment persisted, and experts struggled to get payment that was due to them. She said that the problem is then further exacerbated by the fact that some attorneys had closed their doors. And we presume that is because those attorneys focused exclusively on RAF work. And now that that work was pulled, they then didn't have enough work to continue their practice. Some attorneys had not been paid, and therefore they were not paying the experts. And other attorneys had been paid, but hadn't been paid in full. And so it was not clear which disbursements the RAF was paying them for. So in other words, the attorney then finds it difficult to reconcile accounts and pay experts. So if I give you an example of an attorney's account, it would include various disbursements on there. The attorney may have used the services of counsel, for example. So you would have counsel fees on that disbursement. You would have the attorney's fees. You would have costs for printing, for telephone calls. You would have medical expert costs. And let's say in totality, that bill is 100,000 Rand. The RAF then pays 60,000 without indicating what that 60,000 pertains to in respect of that global amount of 100,000. So that then makes it difficult for the attorneys to reconcile and figure out who they need to pay from that amount. So that would have caused further delays. In November 2020, the acting CEO, Mr. Rambauli, then meets with experts again, and we were provided with a copy of the draft minutes of that meeting by Ms. Minnie. And in terms of those draft minutes, she, or the RAF rather, acknowledges that there is a lack of instructions that are being experienced by some experts, while other experts are being given too much of work, that attempts to reach claim handlers were not successful. So in other words, experts are not able to get the information that they need, that they ought to make payment within 30 days, but they were not making payment timeously. The RAF in that meeting then encourages its own staff to ensure that where there are problems with invoices or there's a dispute with an invoice, that they engage experts timeously. Because otherwise experts are merely sitting and waiting, not knowing whether the payment is loaded on the system, not loaded, whether it's even been received or not received, or whether there's actually an issue with the invoice. In other words, the RAF is unhappy about something on the invoice. It's either not within tariff or whatever the case may be. And she undertook that they would process this backlog and send each of the experts their RYMP. And she also undertook to provide the Medical Experts Representative Committee, which was just a committee of experts representing all other experts with monthly progress reports. So again, notwithstanding these promises, the issue of non-payment persists. And in the circumstances, that Medical Expert Representative Committee then submits a notice of its intention to resign. And that notice cites the RAF's failures to address experts' concerns, including a lack of communication, the inadequacy of their VRS system, pending work, and concerns about the fact that they had SLAs that were about to expire. But they received no response to these serious concerns. Instead, on 9 July 2021, so some months later, the RAF appeared to do an about turn and then issues a letter to experts wherein for the first time it raises the legal defense of prescription. So according to the RAF, there are experts that have submitted invoices dating 10 years back without proof of prior submission, and that, unless a invoice is submitted within 3 years, that payment claim would prescribe. If the expert hasn't interrupted that prescription. And Ms. Mini said that it was her view that this was an unethical attempt to effectively write off genuine claims. And of course, we view this in light of the fact that we have evidence from various submitters that the RAF never had proper invoicing and payment systems in place. But yet experts are thrown this absolute curveball then in July 2021, where prescription is then raised. On 2 November 2021, so a couple of months after this letter about prescription, Ms. Rambali addresses a letter to the panel of attorneys, which obviously had come to an end, but the persons or the law firms that were on that panel undertaking to make payments to them in respect of experts, even where prior authorization had not been obtained. So I guess one must view that as the RAF acknowledging that their own systems weren't fit for purpose, that perhaps they weren't giving authorization where they ought to have given authorization, or they allowed a system to perpetuate in which authorizations were actually not necessary and attorneys were doing as they pleased. Ms. Mini explained that on her books, she's got 35 experts at the moment who are owed a balance of 41.2 million. And some of those claims date back to as far as 2014. And that amount excludes interest. According to her, her own experts on her books never ever claim interest. And in fact, some of the other experts that had written to the committee also indicated that even where they're fighting for payment years later, they still haven't requested interest. She said that she belongs to a WhatsApp group where there are 47 medical experts, which would include her experts on there. And that group in total is owed about 120 million. And to date, the issue that the experts have is that they have no way of knowing what the status of their invoices are. So whether the RAF regards their invoices as prescribed and written off, or whether they are in a queue for payment. So that letter about prescription is a general letter. It cannot be that simply because you've submitted an invoice, when you were asked to resubmit an invoice and you resubmit invoices from as far back as 2014, that you can assume that that has prescribed. Because if you've been following up on that, which Ms. Minnie in her position as administrator of these accounts would have obviously been doing, that prescription would have been interrupted. So they're sitting at the moment really unaware of what the status of those claims are. To complicate matters, she alleges that the RAF is further refusing to make payment in respect of matters where it claims that the panel of attorneys did not obtain authorization. And this, notwithstanding the letter from Ms. Rambauli, and also notwithstanding that the RAF utilized the reports and expert testimony to defend matters. So you have a case where the RAF says you weren't, we never authorized your procurement, and even though we didn't authorize it, yes, we still used your information in court, or we still used your report to assist us in quantifying a claim, but we're not now going to pay you. As I've indicated, her testimony is supported by a number of submissions, and I've just stated one or two examples. One example is in relation to an estate late of an orthopedic surgeon, where the executor indicated that an amount exceeding 14.5 million is owed to the estate. And the executor, in fact, updates us from time to time. They've received no joy from the RAF in respect of this. And obviously, it then becomes difficult to even tie up that estate because of the RAF's refusal to make this payment. In another submission, the submitter provided evidence of correspondence on behalf of more than 55 experts to the Minister of Transport in June 2023, where the Minister was asked to intervene and assist these experts to obtain payment. And that letter, which was drafted by a clinical psychologist, paints a picture of the sort of problems that experts had been facing, and especially since 2019, with the appointment of Mr. Litswalo, that experts have been having nothing, what she describes as nothing short of a nightmare to recover payments for services that were legally and rightfully administered for purposes of settling RAF claims. And she reiterates this issue about confusion, the constant retraction of instructions and directives, and that the RAF also then willfully ended their contract with a panel of attorneys, confusing the system and delaying the process for claimants. I must just let the committee know that Ms. Minnie had given us really a mountain of evidence, and you know, I have taken really the bare minimum to try and put in this section of the report that which I thought was absolutely necessary to just start painting a picture. But you would go down a rabbit hole if you were to start looking at the instructions given and then revoked later on, the absolute mass confusion that was going on. That information, if members wanted, is obviously all available. We've kept all of those records, but it really is an absolute minefield to try and understand what was going on in this period and what the RAF was trying to achieve. The best thing that comes to mind is it really was a case of the blind leading the blind. So that letter also goes on to say that many of the experts have lost their homes and their livelihoods as a result of the failure of the RAF to make payment. Ms. Minnie had given me evidence about particular experts that had to close their practices, downgrade their practices, and so on, those that have lost their homes. So she also supported this claim. Obviously, I haven't put that personal information in the report. The committee then also received correspondence from a Dr. Kapitani, who was one of the signatories of that letter to the Minister of Transport, who wrote to us in May 2026, confirming that the RAF continues to refuse to pay invoices on the basis that the work performed by experts were unauthorized. notwithstanding that the reports have been utilized by the RAF. And then in addition to this challenge of receiving timely payment, Ms. Minnie also raised other system deficiencies, including double payments, and members would have engaged with her on the issue of double payments. So she explained to us, which we heard also from Sunshine Hospital, how the RNYP is a useful tool to eliminate things like double payments and to enable experts and service providers to pick up errors quickly and then to correct them. However, that is obviously only helpful to the extent that it's shared with these service providers and the experts, and not all of them have access to it. There's been undertakings that it would be shared with them, but not every expert necessarily has access to their RNYP. Then I'm moving on now to payment of experts who perform work on behalf of claimants. So as I indicated, it doesn't fall squarely within the work of the committee and the mandate of the committee, but it still remains important. It's concerning that we have experts in this category who are battling to receive payment from attorneys, because in all of these cases that we've received, in all of these submissions, it's a case of these experts doing work via attorneys. So in other words, attorneys have procured their services. And it really points to one of two possible scenarios. Either the claimant's claim is delayed and it hasn't been settled, hence the attorney hasn't been paid. And in the absence of payment, the attorney is not able to pay the expert. And obviously also not pay the claimant. Or in the worst case, the claimant's matter has been settled. The attorney has received the monies. Those monies have been put in trust. But notwithstanding that, the attorney has in fact failed to duly pay the claimant and or the expert. That is obviously extremely worrying, and in both scenarios, claimants suffer at the end of the day. If the RAF hasn't settled matters timeously, it's claimants that suffer. If the RAF has settled the matter, but the attorney hasn't paid the amounts in full, it's also claimants that suffer. The committee's received information from a number of experts on this. One expert in particular provided proof, for example, that attorneys have failed to pay that expert and or the claimant despite being paid by the RAF. That expert has made efforts to report same to the RAF. The RAF initially had undertaken an investigation, but then indicated it's unable to investigate the matter any further. And this is extremely concerning, because at the end of the day, where attorneys are not paying their claimants and also not paying their service providers, it means that the RAF is not achieving its own objectives. And it's extremely concerning that the RAF then doesn't take or doesn't seem to take those sorts of complaints seriously. And you know, one always has the idea that if somebody is a medical expert, they must be extremely well off. These are people that have studied for long periods of time. They earn extremely well. And so there's not going to be major issues if they are not paid in respect of one or two matters. That is, in fact, is not what we've seen. We've actually seen the impact on experts. As I've said, both experts that perform services directly for the RAF, as well as these experts that perform services on the instructions of attorneys on behalf of claimants, that they've really lost absolutely everything. And it's an extremely emotional thing to have to listen to experts on both these sides and to read these submissions that they've made to the committee on this. So in terms of findings, the committee's obviously identified deficiencies. There's poor internal controls and procurement irregularities in the appointment of experts. And we've just noted a few of the serious concerns. The one is there's an obvious failure of the RAF to procure services of experts in a timely manner. You see these long delays in the procurement processes for the panel of experts. And the delays obviously expose the RAF to the risk of non-compliance with procurement prescripts. because you continuously need experts. The expert services can't be compared to the procurement of other goods and services which you may not necessarily need all the time. If I don't procure, for example, water, staff can go and buy their own water. It's fine. It just means that for a few months until we sort out our tender processes, we're not going to be providing staff or guests with bottled water. Experts is the exact opposite situation. You constantly need the services of experts. So what would happen is that if you don't have a tender in place, it would mean that you need to follow some sort of tender process to obtain the services of an expert. So whether you're doing that on an emergency basis as a limited procurement or whatever it is, but you should be following some process. According to what experts have been saying to the committee, in many cases, there is no process that's followed. There were submissions, for example, that indicated that RAF officials visited the office of an expert and asked them to provide services. And experts then did this in good faith and they weren't paid. So it's definitely borne out by evidence that we have experts whose services are utilized even in the absence of a panel of experts or in the absence of those experts appearing on that panel of experts. And it's unclear why these processes would have been delayed, given, as I've indicated right at the beginning, these are essential services. Proper planning would require that bids are prepared and processed in advance of the end date of the current contract. So once you know the contract is coming to an end, some months prior to that is when you should start your planning process. But it appears that this was not the case under the period of consideration. In addition, you then have further delays that were occasioned in respect of the signing of the SLAs, and that exposes the RAF to legal risks, and it also creates uncertainty amongst experts. It's very difficult when you don't have an extremely thorough bid, and I can say to members, having looked at those bids, I would hardly call them thorough by any stretch of the imagination. So the SLAs would have played an important role in that contractual relationship. But you have cases of experts signing their SLAs at the very end of the term of that panel. So really, it just boggles the mind as to why the RAF could not get that right. Then you have the failure by the RAF to carry out adequate planning, research, and analysis of their needs and the supply environment prior to embarking on a bid process. So this is what resulted, obviously, in your practical challenges, which included a shortage of experts, the unreasonableness of the tariff, which submitters indicated to us, the failure of bidders to properly understand the process. And it remains puzzling why the 2018 process was referred to as an RFI, but then ended up being treated as a formal bidding process, when clearly the two are not one and the same things. So, one has to question how many experts didn't respond to that 2018 RFI because they just didn't have time to respond to an RFI. And they thought to themselves, well, when the actual tender comes out, I'll then respond to that. There's no evidence that there's a shortage of experts because there's an insufficient number of experts in the country. It appears rather that the size of the panel, the location of experts, and the type of experts on the panel was informed by poor planning and a failure on the RAF's side to design fit-for-purpose bids. So one would have expected that the RAF would have been able to be in a position where it says, this is the number of claims we deal with per year. Typically, the majority of our claims need the services of these types of experts. Occasionally, we also need other types of experts, typically in these numbers. Most of our claims for accidents are coming out of this province, therefore that province would need more experts than another province, and so on. Because where you have experts that are scattered, you have additional costs because the claimants now have to be sent to those experts in order for them to compile a report, or the experts need to go to where the claimants are. So there doesn't seem to be any evidence of the RAF having done this sort of homework. One would have expected that was the purpose of the RFI, but even the manner in which that RFI is drafted is really not suitable for extracting this sort of information. Then you have the failure by the RAF to ensure that the award of contracts and service level agreements are legally sound. And it was quite shocking having a look at those SLAs that these experts were expected to sign, especially given that the costing exceeds 1 billion. So these are not small amounts. It's imperative that your SLAs then are watertight and that you prepare those with care and diligence. Sloppy contracts show a lack of professionalism, and it's also evidence of a rushed process. You really have essentially one SLA that everyone is going to sign. So you could have spent a number of days ensuring that that SLA was as perfect and as legally sound as it needed to be, so that you don't expose the RAF to unnecessary risks. It also appears that in respect of the 2021 panel, as I mentioned earlier, that board approval was obtained in March 2022, yet the contracts commenced earlier. And these sort of retrospective approvals expose the RAF to unnecessary and avoidable risks, and it calls into question the adequacy of their own governance processes. Because if you had a situation where, for whatever reason, the board did not agree to sign off, and those services or some of those experts had provided services in the intervening period, you would then have difficulties because those would have all been irregular. The committee then finds that the failure to pay valid invoices, and I've specifically said valid invoices here because the committee cannot make a claim that every single invoice submitted by every expert is in fact valid. Of course, there may be invoices that are inflated or even invoices that do not truly reflect services that were provided. But on the basis of valid invoices, the failure to pay those valid invoices within 30 days is a flagrant violation of the Public Finance Management Act and Treasury regulations, which require payment of invoices within 30 days. So unless you're able to show that there's a dispute, invoices must be paid. From the evidence before the committee, there are invoices that are older than a decade which remain unpaid. In addition, there also appears to be serious shortcomings in the way in which invoices are processed, and this has resulted in repeated requests to experts to refurnish their invoices and a failure to communicate with experts where there are disputes in relation to their invoices. Considering this, the committee finds that the RAF has acted disingenuously in raising the defence of prescription in cases where experts can in fact show evidence of having submitted their invoice. It cannot be that experts are prejudiced because of the RAF's own inability to process invoices efficiently, which is what it seems to be. The committee finds that the impact of the cancellation of the panel of attorneys on experts was not adequately addressed and no contingency plans were put in place. And those contingency plans would still have to be in place because the RAF continues to transition to the state attorney model. There is evidence that experts were expected to deliver reports in the absence of clear instructions and sufficient information. And it's very worrying that in some cases, experts provided reports, but because the RAF failed to defend matters in courts, those reports could not be considered by the judiciary. So where reports were provided but not used, and that would have been due to no fault on the side of the expert, the expenditure in respect thereof must be regarded as fruitless and wasteful. And in fact, Ms. Minnie just sent me a WhatsApp a few days ago to show me yet another court judgment where the court bemoans the fact that there was no expert report on behalf of the RAF that the court could consider, yet she has evidence that a report was submitted because the expert is one of her clients. So that can only be regarded as fruitless and wasteful expenditure because you're having to pay experts for reports and then you're not even using the reports. There was further no clear guidance on the contractual arrangement and payment obligations that flowed from work done by experts in the period preceding and especially the period post the cancellation of the panel. It ought to have been patently obvious to the RAF board and management that the cancellation of the panel of attorneys would lead to complications in respect of payment of experts. The fact that experts were instructed 3 months prior to the cancellation to send their reports directly to the RAF means that the RAF recognized that attorneys would no longer act as intermediaries between experts and the RAF, yet they did nothing to ensure that the contractual arrangements reflected that reality. To expect the panel of attorneys to bear the brunt of this inadequate planning and then to deny payment on the basis of lack of authorization is disingenuous. The committee further identified weaknesses in the RAF's payment system. The system failed to recognize that certain payments for experts had already been disbursed, leading to double payments in some instances. In addition, the RNYP does not appear to be routinely shared with experts. And as we've indicated, it's a critical tool in the management of experts and medical service provider claims. Furthermore, it's clear that the failure to communicate payment of claims to all role players, such as attorneys, claimants, and experts, create fertile ground for double payments and the misappropriation by attorneys of payouts meant for road accident victims and for purposes of settling the disbursement costs of experts. So I just want to hone in a little bit on this particular issue. Where people don't know that payment has been made, it's then very difficult to ensure accountability. So notwithstanding that the RAF may have made payment in some cases, as I've indicated, the payment is sometimes not clearly communicated. Payment is made in part, not in whole, and then you sit with attorneys unsure of whether the payment is in respect of in respect of which part of the claim payment is being made. And similarly, Ms. Minnie indicated that it's the same even with experts. So experts sometimes would get paid less than what their claim was, but there's no explanation in terms of what isn't being paid. And that makes it extremely difficult then to reconcile accounts. The committee is then also concerned about allegations of attorneys misappropriating funds meant for the benefit of claimants. It's something that has been raised quite strongly from the beginning of the process, and in fact raised by Mr. Litswalo prior to his departure. It notes that this misappropriation also affects other service providers, like experts who have provided services in good faith to claimant attorneys. So notwithstanding that our focus has been on experts who have provided services to the RAF, I don't think that we can ignore the fact that we also have other experts who have provided services via claimant attorneys, and they still haven't been paid. The RAF cannot operate and function as an island. Monies paid by the RAF are public funds. It's meant for the benefit of claimants. That is clear in terms of the RAF Act. It's not meant to unlawfully enrich attorneys. So where claimant fails to be paid, or an expert or any other person to whom money is owed in respect of that claimant's claim, it translates into a situation where the RAF cannot be said to have achieved its objectives. So it's not fine for the RAF to simply turn a blind eye to requests for information on payment. And in fact, we saw even during our oversight visits that claimants were complaining about the fact that they themselves don't know if anything's been paid to their attorneys. When they try to request information, they're told to go back to the attorneys. You can't go back to a corrupt attorney and ask that corrupt attorney whether the RAF has paid, and if they've paid, what they've paid, in order to hold those attorneys accountable. And I think it is quite important that the RAF functions in a way that makes this information easily accessible so that there can be accountability from all corners. The RAF merely making payments to attorneys on behalf of claimants doesn't resolve the problem until such time as that money reaches the hands of claimants. Chair, that's it from my side on the issue of experts. Thank you.
Thank you very much, Ms. Ibrahim, for taking us through that report. I'd just like to share two anecdotes with the members. One from a couple of weeks ago, and another from maybe several months ago. A couple of weeks ago, somebody kind of came to me and they indicated that they are a judge in the Pretoria High Court. And he begged me that the members must go and sit in court and just listen to the cases that he presides over, and how angry they make him, because the Road Accident Fund overpays on these claims, but there are several problems with the Road Accident Fund's defense. In most cases, there is nobody there to defend the Road Accident Fund. And while as a judge, he can ask questions of the counsel, he can't fight the case for the Road Accident Fund where they don't have somebody there. So that was the first thing. The second thing, though, also had to do with this issue that we are discussing today, where the size of the claim hinges on the expert's report. And when the Road Accident Fund is not there, it means they don't have an expert to counter the argument that is made. And therefore, there have been awards there which are bigger than they should be. And he knows that the Road Accident Fund will probably apply for a rescission, or the money will just get paid, even though the Road Accident Fund should have never paid that kind of money. So he basically said, please, your committee must just come and sit there in any of the courts one day and listen. He said, by lunchtime, we will all be screaming and pulling our hair out because of the kind of cases that sit there. So this does speak to what becomes later on another problem, which is to see these huge claims being paid, huge sums of money to attorneys and that kind of thing, because there are all of these deficiencies in the system. So that was one. The second is it's just that I'd asked the person to make a submission, but they didn't. It was a young man. I met him at Menlyn, Maine. He came up to me. He said he's an I don't know, occupational therapist or something like that. One of the psychologists. I might be getting it wrong. And he had moved from Durban from eThekwini to Pretoria, his practice. And he says the biggest mistake of his life was taking on RAF clients, because he realized too late that getting payment on these clients was going to take him a heck of a long time due to various problems that they had administratively at the Road Accident Fund, files getting lost, an attorney no longer being there, was acting on behalf of the Road Accident Fund, and so on. And that he really nearly needed to close his practice because the impact on his ability to pay rental and that kind of thing was severely impacted. So, I mean, with these two anecdotes from my side, it's clear that there are people who are in the sort of expert environment who are severely affected by the challenges that the Road Accident Fund has had over the years and that they continue to have. And I think the importance of mentioning the case from a few weeks ago is to say these are not problems that used to happen a long time ago and no longer happen. They're still happening even now. So that is why I think for me, this section of the report is so important. But let me give the honorable members an opportunity to make comments and suggestions, and then we will close out in the usual manner, and then we will discuss the speakers later. Honorable Beasley.
Thank you, Chair, and once again, thanks to Ms. Abraham and her team for an excellent report. And I think what Ms. Abraham said, it didn't actually find its way into the actual thing, but she spoke, I think, two things: mass confusion and the blind leading the blind. And whenever we just read these reports, we just see what a wrecking ball it has become at the RAF, and it's not getting better, Chair. And so I just think those were two things that stood out for me: mass confusion and blind leading the blind. And the sad thing is, it's a victim of the road accident funds. In fact, everybody just loses out with this. Do we have an idea of what the quantum of these total claims are that haven't been paid yet? Because obviously the RAF don't keep it as a record, but I think it'll be very difficult to provide an estimate. But once again, we're talking potentially billions. And then just a follow-up question is, if attorneys are getting paid and they're not getting told what they're getting paid for, it's be quite difficult, I would imagine, for them to disperse payments if they actually don't know what they're getting paid for, because it was mentioned there that some experts are owed a huge amount of money, they get paid, that they actually don't know what they're getting paid for. So I think that is a big weakness in the system. So I think to paint all attorneys badly, I think there's definitely some unscrupulous ones out there, but I think if you're not knowing what you're getting paid for, it's quite difficult to disperse the funds. And I think that is a big issue. Just if the RAF are making disbursements and it's not clear and not transparent what they're actually paying for, you'd think there'll be something on the site saying this claim is paid out, so the actual claimants, the actual victims, could be able to see what's being paid out, what hasn't been paid out. But once again, I think the statement of the blind leading the blind is very apt. So that's my input. Thank you, Chair.
Thanks, Honorable Beasley. Honorable Skosana.
No, thank you very much, Honorable Chair. Good morning to yourself, fellow members, and our support team and other stakeholders present. No, we appreciate this part of the report from our support team, Ms. Ibrahim and the entire team. We really appreciate it. I think it's quite comprehensive, and it's a true reflection on matters that were ventilated before the committee by Ms. Mini and also other witnesses. I remember vividly when Ms. Mini appeared before the committee and all these matters as they are being captured in this particular report. Yeah, it's quite a very sad story, Chair. I don't know if I should say this RAF was run. It was they were running it like a spaza shop. I don't know if I should say that, because I know some spaza shops which are being run better than how the RAF is being run. Because I know there are some spaza shops that don't have these till machines, which you are able through the till machine to scan the unit of every item that is being bought, and also determine the amount that the person is supposed to pay and the change that the person is entitled to, if any, and then also issue a till slip for the buyer, but also remain also with a copy of the till slip for reconciliation later, in order to determine how many items were bought for each unit, and how for how much, and then how much have we received, and then so that we are able to make a proper reconciliation. But then we find tax officers who don't have those till machines, but then they would have a calculator and a notebook. If somebody buys something, then they will use a calculator to calculate how much the person is supposed to pay. If he is buying few items, they would add and subtract and do all that. Then they would also record in the notebook, so that when they have to reconcile, they are relying on the notebook to say how many units for each items were bought today, at how much were bought. So I don't know if I should say RAF is being run like tax shops, because I know tax shops that are run proper, even better than the RAF. So really, it's quite a sad story, especially for road accident victims who are the ones in the main who have been prejudiced by the whole system. But also, it's not only them, even other professionals like the medical experts that we're talking about, who have also suffered from both sides, those who are working for the RAF and those who are working for attorneys that are representing road accident victims. So from both sides, we've got legal experts who have also suffered a lot under the hands of the board and the management of the RAF. So it's quite a sad story indeed. The issue of 41 million rand that Ms. Mini talk about, that some of her clients are being owed about 41 million rands. But there are others who are not headlines, but who are also in the same field. When you combine, the amount would go to more than 100 million rands. So it's quite just a very, very sad story to listen to. So I think indeed at the end of the day, we need to make serious recommendations in order to turn around the situations and to avoid these kind of things happening in future. Yeah, no, but all in all, Chair, I just want to appreciate the manner in which the report is crafted. Indeed, it's indeed, in my view, a true reflections of the matters that were ventilated before the inquiry. So thank you very much, Chair.
Thank you very much, Honorable Skosana. All of those are noted. I have to say, when you went through the list of things that need to be done to run a spaza shop properly, I thought that you could run a spaza shops very well. Honorable Nilme?
Yeah, okay. No, thank you, Chair. And no, thank you very much. Chair, I'd like to thank the team that have put the report together, and especially from our legal advisor. Chair, it is deeply concerning and frankly shocking that medical legal experts who play a critical role in the adjudication of RAF claims, that they still remain unpaid for services already rendered. I think that is something that came out in the report. Not only that, the prolonged non-payment has had a direct impact and a detrimental one on their livelihoods, affecting their ability to sustain their practices. I think that is one of the areas that you mentioned as well. And I think if you are owed that amount of money, it just doesn't make sense that you would survive. I think, notwithstanding this, it's noted with concern that the Road Accident Fund was then still using their same reports during the litigation processes. I think that was a little bit unethical from that side. The findings of the report are clear in identifying serious deficiencies within the Road Accident Fund, including obviously the weak governance, poor internal controls, and procurement irregularities that have contributed to the current medico-legal crisis. The contradiction raises serious concerns about the fairness, accountability, and the credibility of RAF's litigation strategy. Chair, the findings on the report have been captured very well. From number 45 to 50, I think it has been well captured. And I think with our recommendations, we really do need to look at what recommendations we're going to put forward. But I do feel that we should do that. Thank you, Chair.
Thank you very much, Honorable Nilme. Honorable Skosana?
Thank you, Chair. I'm aware that I've missed a lot in terms of what was happening because of the ad hoc committee.
You didn't like us that time.
No, not really. But be that as it may, Chair, I know that the communities and different people are saying the same thing about Parliament, that we are running Parliament like a Stockfell or we are like a spaza shop. So I don't want to point fingers on that, because in short, I'm saying I've read the report. I'm really, as well as a parliamentarian and as a citizen of this country as well. And I think that we have to encourage our society as well because of what is happening on the road. it really leaves much to be desired. The recklessness which I'm seeing, and I know that that's a debate for another day. I'm just raising that to say, if you look at what this accident are causing, the amount involved, in this matter which we are deliberating here, if our society can really as well be good citizen on the road, we won't be where we are today here. That I know for other people, this is how they sustain their lives. You need to have lawyers getting involved in this matter, people working and all that. But be that as it may, the caption of this, the report of this, you call them experts, Fatima has said, and I'm saying these are consultants in my own world, is that they've done a good work in the report, but indeed there's a lot of improvement because this thing is across the board. It's not only ref. Okay. We'll be fooling ourselves. We are sitting in those meetings at Scopa and the other portfolio committees. It's across the board. The government has failed our people, period. It's not about ref. We'll be fooling ourselves. The municipality, as you know, we sit there, we know what is happening in this country, But on this one, let's see, Chair, whether the scrutiny and the report when it comes to Parliament as well, and there'll be consequences. And from my side, I really appreciate the report, with a pinch of salt. And indeed, I'm just urging my colleagues as well that when we go to our society, let's preach, our people, in particular, our own executive. Yeah, not anywhere, the way they drive on the road. It's not easy for us to be able to reduce this accident, but it will help a lot to reduce accident on the road as well, to make things easier for REF as well, to have not so much work to do about accidents. Thank you, Chair.
Thank you very much, Honorable Skosana. Much appreciated for those words, because I think that one of the reasons your message is even more important is that apparently with more electric cars on the road, even the ability of the Road Accident Fund to make the payments or the revenue that it gets is going to start dropping because of the fewer people paying the fuel levy. And ultimately, it comes down to behavior on the roads, which is going to reduce the accidents. Other members, I just want to be sure that there are no more questions. Honorable Nel, may I see your hand still? I just want to be sure that it's an old one.
Sorry, Chair, it's an old one. Legacy.
Okay. Thank you very much. So can I ask, I don't know, Ms. Ibrahim, if you've got the speaker's letter, because that would then be the second item on the agenda.
Yes, Chair, I'll just ask the Secretariat to put it on the screen as well.
Put it on the screen, yes. So before you begin, so I got this letter at the end of last week, basically, but because it was a weekend and I knew that we would be having this discussion today, I decided to share it today, also to give the committee an opportunity to discuss it first in case it kind of slips out of our collective custody and it ends up being a topic of discussion before the committee has had an opportunity to discuss it. But the speaker has written back. I will not interpret it for the members. I will ask Ms. Ibrahim to just take us through it. And then it's up to us as a committee to decide what to do with our own resolution in light of what the speaker is saying. But obviously the views of the members are critical in this respect. So can you please just assist us, Ms. Ibrahim?
Thank you, Chair. So, Chair, just as a refresher, the committee will recall that Mr. Letswalo was scheduled to appear before the committee on 25 and 26 of November last year and subsequently did not appear. And following that, the committee then resolved that it would lay charges in terms of the Powers and Privileges Act. And what we had done is I had indicated to the committee two things. One is that we don't have a precedent in Parliament for the laying of charges in terms of the Powers and Privileges Act. To the best of my knowledge, it has never been done before. There are quite a few cases of political parties or members acting as individuals going and laying charges, but we don't have precedent of a committee doing it. That was the one. Second was that there was an issue around the interpretation of the Powers and Privileges Act. The Act, Section 14.4 to be exact, requires that summons must be served by the sheriff or by a person designated by the secretary by delivering a copy of the summons to the person mentioned in the summons or to that person's usual or last known place of residence or employment, to that person themselves, or to a person over the age of 18 years. And the issue that we had was that members will recall that the sheriff was unsuccessful in serving that summons personally on Mr. Litswalo. And we had then gone back to the Secretary to Parliament. We slightly amended the summons to allow for what we had called substituted service by means of advertising it on social media, the parliamentary website, sending it again via email and SMS and so on. But I'd indicated when I gave my legal advice last year that there can, of course, be an argument made that what the Act is requiring is personal delivery of the summons, so to deliver it in person to someone, and it would really ride on how one looks at that wording. When you say deliver a copy of the summons to the person, can that possibly be interpreted as delivery by any other means, so via email, electronic delivery? I noted the fact that the Act doesn't say in person, it says to the person. And last year, when I considered the matter holistically, I was of the view that I, as a legal advisor, am fairly confident that Mr. Litswalo had full knowledge of the summons, but still didn't appear notwithstanding. So the objective of the Act, in my view, was achieved. And the objective is that you need to make sure that the person has knowledge of the fact that they expected to appear before a committee of Parliament. That being said, I also noted the fact that because we don't have precedent, practically we don't know what the process is that must be followed, and the Act is silent on the process. But given that we had asked the Speaker for concurrence, let us write back to Speaker, because perhaps at the level of Speaker, they would be aware of another similar matter or would be able to guide us in terms of the practical way forward. And we wrote to Speaker. There was quite a long memo that was sent to Speaker where we set out in some detail the history of correspondence between ourselves and Mr. Litswalo, all the efforts that we made to secure his attendance, the objections that he had to attending, and also letting her know that the committee has resolved to lay this charge. And notwithstanding that her concurrence isn't required in terms of law, we are sending it to her to consider. The Speaker then sought independent legal advice on the issue. And in terms of that legal advice, the Speaker has now written to us. And in short, the letter confirms what we already knew in terms of the legal position, that concurrence of Speaker is not required. But what the Speaker does mention is that legal advice, and I've obviously considered that legal advice myself as well, is that independent legal advice does advise that there is a risk of a prosecution being unsuccessful, because if the Act is interpreted in such a way to read that summons had to be personally served on Mr. Litswalo, then obviously a charge wouldn't be successful, and it would be unlikely that the National Prosecuting Authority would even then consider such a matter. So Council was of the view that whilst the summons was properly authorised, so in other words, the process that the committee followed to summons in the first place, that was properly authorised,
the Secretary to Parliament had duly signed the summons, but in respect of the issue of delivery, that they do have concerns that perhaps there's a flaw there and it may be defective, but that his actual knowledge may support an argument of substantial compliance. So that one really is a little bit up in the air. They also considered whether he had sufficient cause for his failure to appear before SCOPA, and they were of the view that he wouldn't be able to show sufficient cause as to why he didn't appear. Because his failure was really on jurisdictional grounds. Members will recall that he objected to the authority of SCOPA to conduct the oversight inquiry, and we had dealt with that one-on-one with Mr. Letswalo. We had responded, providing reasons why, in our view, the committee could continue, and the Speaker had a similar view. And of course, had he wanted, he could have still attended on 25 and 26 November and raised these matters there. It wouldn't have been a basis for him to simply then ignore the committee and not attend. So whether it's a criminal offence or not would obviously depend on this issue of whether that summons was duly served. Council's view was that if you want to be 100% safe, then what you could do is simply try to serve summons again and secure his presence in that way. Alternatively, you can take the risk of laying a criminal charge, but the prospect of success may be weak to moderate if we can't prove that the summons was duly served. But they reiterate that the final decision to prosecute rests on the National Prosecuting Authority. Other questions that were also raised with council was whether what would happen if Speaker doesn't grant concurrence. And council reiterated what we thought, that there's no express statutory requirement for Speaker to concur, so you don't need Speaker's concurrence at all. And then we also asked a question in relation to whether a decision to lay charges should be supported by a resolution of the National Assembly, or does a resolution of SCOPA suffice? And council confirmed again that the Powers Act doesn't prescribe a referral mechanism to the NA, and an NA resolution would not be required by law. It was council's view that it may be prudent in appropriate cases where a matter is politically contested or internal authorities challenged. That is a view that I disagree strongly with, for the simple reason that something like laying charges should never be a political decision. Because when you have situations where, let us assume that summons was 100% validly served, where you have a situation where it's been validly served and you then allow the National Assembly to make a decision as to whether you should lay charges or not, it means that you're allowing that to become a purely political consideration. There wouldn't be any rationality then necessarily, because what do you do when it's clear that somebody hasn't appeared when they were meant to appear, but the House then resolves that we don't lay charges for whatever reason. And then in another case where somebody doesn't appear, the House then resolves that we do lay charges. We can't have that risk of unfairness. So that was something that I disagreed with. But in any event, it's neither here nor there, because the Act doesn't provide for that. So the letter from the Speaker is basically simply saying, I don't need to give concurrence to this committee in any event. In my role as Speaker, I don't get involved in the day-to-day business of the committee. However, I'm going to bring to your attention this independent legal advice that I've received, and the committee must now decide as to how it wishes to proceed, bearing in mind that risk. So if you proceed to lay the charge, there is a risk that the NPA doesn't take the matter further, or even if they do, that you're not successful in the matter. Alternatively, the committee can consider whether it wants to summons Mr. Letswalo again. She has advised that if the committee is of the view that we are going to proceed with it, that we ask the Secretary of Parliament to assist in the actual laying of charges. That was something that we had included as a recommendation in the memorandum that we had initially sent to the Speaker. So in other words, just to get the assistance of the Secretary to Parliament to do that. Somebody would need to, for example, depose to an affidavit. It's likely that the Secretary to Parliament would delegate that to a staff member in the committee who would have first-hand knowledge of it. But it really is now, Chair, in the hands of the committee to decide the way forward, whether it would want to accept that risk or whether the committee is inclined to call Mr. Letswalo again, or alternatively, if the committee doesn't want to do anything at all. The last course of action is something that we wouldn't advise that the committee does, because obviously that then sends out a incorrect signal that Parliament doesn't take these sorts of things seriously, and it may open a Pandora's box where other people that are requested to come and appear before committees simply don't do it because they know that there's no consequences attached if they don't. So that's definitely not a course of action that our office would advise. But we leave it in the hands of the committee to determine the way forward, Chair. Thank you.
Thank you very much, Ms. Ibrahim. I nearly said Honorable Ibrahim. So thank you very much, Ms. Ibrahim. So there is the letter from the Speaker, honorable members. I will now invite comments from you in terms of how you believe, in light of its comments, how we should proceed as a committee. I'll take Honorable Beasley first.
Thank you, Chair. Yeah, without doubt, I think we need to proceed. We need to proceed urgently. I think the evidence before us is that under Mr. Letswalo's watch, the RF has become a wrecking ball. He was summoned to appear. He failed to appear. And I think Parliament, we're just going to become another talk shop if we don't act. And I think we need to accept that there may be some risk involved, but I think with any laying of criminal charges, there's always a risk. So I would 100% support laying the charges, and I think we need to do it as soon as reasonably possible and not delay it, because the country's watching us and we do not want to become another talk shop. There needs to be accountability for non-appearance before Parliament. So I fully support the laying of charges, and urgently so. Thank you, Chair.
Thank you very much, Honorable Beasley. Honorable Neil May.
No, thank you, Chair, and thank you for the presentation of the Speaker's letter. Okay, Chair, I want to concur with Honourable Beasley in this round. Firstly, Mr. Letswalo, he failed to comply with lawful summons. I think that is it. We know he received it. We know from the comments. We know from his media briefings, his media interviews. He knew everything that was going on our committee, and he knew that there was a summons out for him. I think his conduct undermines Parliament's oversight authority. I think that is one of the most important things that we must take into account. But at the same time, I think we should be leading in this case. I think it could be, we need to set the precedent that we need to lay. We could either try and summons him again, but otherwise I think we should lay charges. I really do think we should find a way to do that. And if it means we need to change the Act or any kind of legislation, because I think this is the 7th Parliament. It's not business as usual. We are going into an area whereby we want to make changes. We want to make a better life for South Africans, and we at the same time we want to clean government. We want to clean up all the wrongs that have been there in the past. And I think going forward, this is very important that we lead by example. We go ahead. This is uncharted territory, and if it means we have to go ahead and look at what needs to be changed to make sure in future that people are.
Good morning, Chair. Good morning, colleagues on the call. We hear the letter.
Sorry, Chair. The volume. I hope the team, the I team, they must raise that. The volume is terrible now.
Okay, sorry, Honorable Member, who can't you hear? Couldn't you hear anybody? Or is it just Honorable Member that you can't hear?
No. Even the last speaker, I don't know whether they've lowered the voice there, the volume on Zoom, because I can barely hear it. I'm not sure about other.
I could hear Honorable Skosana, but let me ask the other members. Members, have you been struggling to hear the other members speaking, or Ms. Ibrahim?
Not at all, Chair.
No, Chair, all clear.
Okay, Honorable Skosana, there might be something with your setup. I don't know if it's
the other one who says all clear. I can hear him very well. I don't know why, but you as well, you are sounding like in a corner. But short, thanks, Chair. We can go on.
Could you hear me clearly?
I can hear you. It's fine. We can go on, Chair. It's okay.
All right. No, thank you. Sorry, Honorable Member. Please go ahead.
Sorry.
Okay. No, thank you, Chair. We hear the explanation, or rather the information of what the letter is trying to say to us. And I'm sure all members do know the position of the EFF in this regard. There is two things I would like to hear from Ms. Ibrahim, because she says Parliament, or rather the committee, has dealt with the issue which the former CEO was complaining about. And I'm not sure how it was dealt with, because there are legal papers that are involved in this. And I'm not sure when will Parliament learn, because we must always be corrected by the Constitutional Court on wrong things, especially that are concerning issues of law. Law advisors of Parliament, they always get things wrong. And all the time they are guided. Can we be guided correctly and not be told as a committee that you can act, you have to act? But there's no such a thing called you can act or you have to act. You must teach people a lesson. And of course, Parliament, when it summons people, people must appear in Parliament. Otherwise, it will not be Parliament. But if Parliament itself doesn't have proper rules in place to hold people accountable, and we have held people accountable previously, even in the ad hoc committee, Commissioner Skosana could also assist us. There are people who tried to escape the committee. They were summoned. They came. Why is it difficult? What is lacking in Parliament, if ever, we are not challenged legally? Because there's no such advice as use your own discretion, act, but you have to act, but you no, there's no such an instruction, or rather advice. This is a legal matter. And as far as I recall, there are papers and there are legal recourses in place. And also, the Collins Lutwalo himself had subjected some of these issues to the legal conversations within Parliament. So I'm not understanding what we're doing. I really don't understand what is it exactly that the legal experts of Parliament or advisors of Parliament are telling this committee to do pertaining this issue, and how far are the arguments between the person who is involved, who was supposed to be summoned, who have also advanced his own explanation as to what were the shortfalls that hindered, or rather prevented him from coming to Parliament. We ought to not be delinquents when it comes to this and act with emotions. We all want Parliament to be respected, but Parliament cannot be respected when it breaks the law itself. There can't be a Parliament which operates without rules, without law experts, without proper provisions in place as to if this happens, what then? All that I know is that in Parliament, all members of Parliament are welcome to go and open cases when they feel like it. We have seen many cases being opened against ministers, against HODs, against DDGs, against departments. We have seen that happening. But we can't be told as a committee, no, you have to act, find it with no, there's no such a thing as a discretion. This is law we're dealing with. We're going to be corrected by the Constitutional Court on doing wrong things. But the EFF already in the beginning had vented this thing of how correct is this committee, and we had explained why this could be a problem in a long run. Thank you, Chair.
Thank you very much, Honorable Member. Ms. Ibrahim, do you want to comment on this?
Thank you, Chairperson.
Chair, before Mr. Ibrahim, because otherwise it's going to come back. We won't finish at 12.
No.
If you allow me. Thank you.
No, Honorable Scott, I think let's just give Honorable Bimno the benefit of a response. I think we'll have enough time between now and 12, because the other members merely registered an opinion and didn't ask a question, and I think in this case, Honorable Member deserves an answer. Go ahead, Mr. Ibrahim.
Thank you, Chairperson. Chairperson, indeed, Mr. Letswalo had, via correspondence to the committee, raised his objections to the committee embarking on the inquiry in the first place, and he set out the reasons for same. We dealt with that via response to him on several occasions. So there was an exchange of correspondence. It wasn't simply one letter received and one reply to it. It was an exchange of correspondence over a period of time. And the matter served before the committee also more than once this question as to whether the committee could continue with the inquiry or not. The committee decided that based on the legal advice that it had received from myself, the committee didn't seek at that point external legal advice, but the committee was of the view that it could certainly proceed with its inquiry, which it did do. The independent opinion from Council, the question was asked and Council dealt with it briefly and was also of the view that Mr. Letswalo would not have grounds for refusal to attend. Those sorts of jurisdictional issues that he raises, he would still need to attend, and he could have raised them again in person when he attended the committee if he wanted to air those things again. But in law, we always advise that Parliament continues its work in the absence of an interdict stating otherwise. And we've advised consistently on that in all of the inquiries and matters that we deal with when it comes to oversight. So if Mr. Letswalo was of the view that there was a legal hindrance in the committee continuing, nothing would have stopped him from approaching a competent court to seek that interdict. He did not do that. What he did do was write to us, and we wrote back with our reasons. And the very last letter prior to the scheduled appearance indicated that we stand by the view that the committee is legally able to hold the inquiry and that the committee is continuing with the inquiry. What I have advised is that I don't think that it would be rational for the committee to do nothing. Where you have a case of a person having been requested to appear before a committee, and whether that was via summons or even just a written request and people refuse, there has to be something that Parliament does in order to deal with the issue, because otherwise you, as I said, you open a Pandora's box where any person that's asked to come before Parliament simply says, I'm not going to come. I don't even need to give you reasons why I'm not coming. What I have said is that there is a legal risk if you continue with the laying of a criminal charge. I've pointed that out because of that interpretation of the Act. If the Act is interpreted in such a way where we focus on whether the objective was achieved, i.e., did Mr. Litswala have noticed that he was meant to be in Parliament but willfully failed to appear? That would be fine. That would likely be successful. If it is the case that the court deals with it, that the precursor was that the summons had to be handed to him by hand, so personally in his hand, then obviously that's a red herring and you face a problem. I don't have an answer as to how the court would deal with that. Obviously, if criminal charges are laid, that would be the defense that would be raised. Alternatively, the committee could decide that they're going to try to summons him again, and the committee would be at liberty to do so. That process we would follow exactly like we did the first time around, where we would first write with an alternate date, and if he persists in his refusal to attend, we then may resolve on summons. So certainly, as far or to the best of my knowledge, we've responded to those legal issues raised by Mr. Litswala, and he's taken no further legal steps to prevent the committee from continuing. Thank you, Chair.
Thank you very much, Ms. Ibrahim. Honorable Skosana.
Thank you, Chair.
Yeah.
Is it Skosana me or the other Skosana? Chair?
Sorry, now I'm confused, Honorable Skosana.
Because it was me.
I thought it's you now.
Yeah.
I thought it's
Yeah,
you
it's
now.
me,
I thought
yes.
it's you now, and
Yes.
then
Yes,
and
that's
then Honorable
Skosana, the young
and
one.
then Honorable Skosana,
Yeah. Thank you, Chair. I just want to say as well, Chair, this ref issue should not take a lot of our work because we have other reports, I guess, which we have to deal with. It's like now we are targeting, a particular person. Because I remember when I was still active, before the ad hoc committee, there was an issue that Mr. Litswalo came into Cape Town, but he was prevented by a board not for him to come. There were a lot of issues, but legal issues, I'm a bit concerned about our legal department, parliamentary legal department, in many issues. And I think Honorable Mente is correct. We should not be corrected by the Constitutional Court again, because there's many times the Constitutional Court has to correct us, and I hope this vigilancy as well will be done with Palapala. I'll always say that in passing, that with all these things, to say people must be held accountable, this is a service administration, it should not only be biased, it should be straight and say in everything as parliamentarians where we are involved, this vigilancy and to deal with matters, or like Honorable May has said, we need not to be focus and only focus on one issue. These other reports as well, which came before us, must be dealt with, equally so with this matter of ref. It will not be like ref is the only priority in our dealing in terms of scoper, and the issue of legal, because legal matters are matters of opinion. To say that one a council gave a report or an advice that we have to deal. The other council can oppose that and win that against us. So I'm saying we should not only rely on that, but for us to say the sheriff must change now because he can't summon Litswalo, or for whatever reason, now they have to change laws to say no, we can do it the other way around. No, let's follow the law. If the law says you must serve him, try to get hold of him. I don't think it's a fugitive. I think if he has to be found by those sheriff, they must do their job. But it should not be us as well, being seen that now we are chasing a person, a person in particular. It's no longer about RAF. Now it's about a particular person that we want to teach him a lesson. And I think I agree completely with the Honorable Mente on that, to say the issue of us as parliamentarians, we have to be cautious, and the legal department must do its work, but we should not be found wanting, because we've seen that, many times, not necessarily in this 7 administration, because some of the legal people, they've been there, some are, served in the 4th administration, 5th, they are still here. So I'm saying, Chair, we have to be very cautious on this matter as well. Let's not be found wanting and be viewed as that we want to we are particular obsessed, with one particular matter. We've got a lot of reports here at SCOPA. It's not only about REF. Thank you, Chair.
Thank you very much, Honorable Skosana. So, honorable members, I just wish to say that I think it's okay to make general comments about the legal department, but I'm also wary of a situation where we've had an experience in this inquiry with the legal department that has really been excellent so far. And I think even the caution to ask the speaker was due to the legal advice of the legal team that is supporting us in this inquiry. The only thing I would urge members is that let's isolate experiences from other committees and other discussions, which have a life of their own, and not bring them here to influence how we then the extent of the anxiety and so on. Let's consider the facts and the merits on their own, and then make a determination of how we go forward. I will give my own opinion on this matter at the end when everybody has spoken, but I just want to say, so far we've been very well served by the legal team, and I think I speak on behalf of a lot of us in saying that, yes, there might be negative experiences elsewhere, but I just urge that we confine ourselves to our own experience in this process in our comments. That's not to say we all need to agree on that, but so far, in my personal opinion, it's been good. Honorable Kubeka.
Thank you, Chair. Good morning, colleagues. Chair, the speaker, with the letter that was written to you from the speaker, it lists, or it says a couple of things that I think we should be very wary of. Now, I understand that some colleagues here are of the view that we should proceed and institute legal proceedings against Mr. Letswalo. But I would like us to properly heed what the speaker is saying here. In that, she's basically saying that we must be careful that whatever that we do or whatever prosecution that we institute may not be successful. And she's basically saying that I think it's the PIPLA, Parliamentary Privileges and Immunities Act, that they may need to go and review that before we can actually proceed and be successful. Now, in that event, I think, Chair, we need to be very careful what we are saying and what we are doing. Because whatever it is that we say and do, we don't want to become a laughing stock at the end of the day when we fail to prosecute Letswalo, because he's used the same things that the speaker is warning us about now. Because the speaker is basically saying, and in this letter, and I quote, "I wish to bring to your attention that I am advised that the committee may face a hurdle insofar as it was unable to serve the summons personally on Mr. Letswalo himself. Whilst your memorandum noted that the committee is satisfied that Mr. Letswalo had knowledge of the summons, but still failed to attend the hearing as required of him, there may be a risk that a prosecution may be unsuccessful because of the manner in which Section 14 of the PIPLA is drafted." So now, I think, Chair, we need to be very wary on how we proceed forward, because the likelihood is the reason behind Mr. Letswalo's refusal is that he already has this legal advice, that he does stand a chance to challenge us in court and he may win. So may we please be very, very careful how we proceed with this. I know it's going to go to a vote at the end of the day. And if we do vote to prosecute, may we please be sure that we are prosecuting something that we're going to win. We don't want to be a laughing stock at the end of the day when it is said that SCOPA tried to prosecute Letswalo and we didn't win. And I do understand as well, Chair, that if we're going to say we're going to wait for the Constitutional and Legal Services Office
to conduct a review of the PIPLA. That may take a very long time, and we may end up leaving this administration without Mr. Latola being charged if we're going to wait for that. So I think maybe consider all of those, Chair. Thank you.
Thank you very much, Honorable Beggar. I think the Honorable G's Kosana was up.
Yeah, no, thank you very much, Chair, for the opportunity. No, we welcome and appreciate the response from the Honorable Speaker to our letter that we wrote to her somewhere late last year regarding this particular matter. And I think we are noting the contents of the letter, which Ms. Ibrahim, I think, has correctly articulated them. One, the speaker says that we don't need a permission from her, which is something that we knew even before we wrote to her, like Ms. Ibrahim has indicated. We appreciate that. But then number two, the speaker says that it is the committee, it is within the committee's responsibility to do that. If the committee feels like laying a criminal charge against Letswalo, it's up to the committee. And if the committee elect to do so, then the committee should then consult the Secretary to Parliament. It should request the Secretary to Parliament to do so. However, the Speaker is also cautioning us that there may be a risk. She says we may face a hurdle based on the issue of the summons as to whether was Mr. Letswalo duly summoned to appear before the committee on the basis of the fact that he didn't personally receive those summons and sign for them, or maybe another person from his home received them. I think the Speaker is cautioning that we may, I think he's using the word which we must underline. He says we may face a hurdle. He does not say you will face a hurdle, but he says you may face a hurdle. So I just want us to underline that, and then and the Speaker obviously, like she said, she can't direct us what to do. So it is up to the committee to take a decision on this matter. I just want to bring the attention of members to Section 17 of the Powers and Privileges Act, that says that a witness who has been formally summoned commits a criminal offense if they fail to attend at the specified time and place without a sufficient cause. And it says that it would also list other areas of committing a crime. But then it goes, then when it talks about the recourse or a penalty, it says if convicted of an offense under this section 17, the non-compliant individual is liable to a fine or imprisonment for a period not exceeding 12 months or both. So it shows that defying summons, it's a serious thing. So we need to take that into consideration as we discuss this matter. But I know that the question on the table is whether was Mr. Collins Letswalo duly summoned. You see, that's why I think the Speaker raised the issue of caution on the basis of his family. I think Ms. Ibrahim has indicated that they were served, summons were delivered. Well, there was nobody there. Then they had to look at other ways of making sure that those summons reach him. They used email, they used text messages, and then they used social media and all that. But now there's a legal argument as to say, can we then regard that he was then duly summoned if we have use email, text, and social media and so forth. But I think my view is that let's allow a competent court of law to resolve this matter. Because like the speaker indicated that there's no case law on this matter. A matter like this has never been tested in a court of law. That a person summons were sent to him or her in different manner, but we don't have something that physically that can produce that this person has acknowledged receipt of those summons. So it has never been tested. So I think this is a golden opportunity for a matter like this to be tested in a court of law. Because if Mr. Letswalo says, I have not been duly summoned because I did not physically receive the summons, and then we are also demonstrating on our part to say, this is what we did, we tried, we delivered those summons, but we further used other means. We used his email, we used his text, we sent text, we used text message through his personal cell phone, we used social media. So we will also have an opportunity to demonstrate in a court of law to say what are the steps that we've taken as the committee to reach him. And then it is the court of law that will then says, looking at what we are going to submit in the court and what Mr. Letswalo will be submitting, then the court of law will make a determination whether he was duly summoned or not. Because the problem, Chair, that we have is that we are a parliamentary committee and our meetings are being televised. So any person who we are going to issue summons to, he or she will obviously know before that we have taken a decision to summon him or her to the committee. So that person will do like Mr. Letswalo did and run away from receiving those summons. So what then do we do? You see, we are unlike other institutions which they will have meetings behind large halls and in committees where other people won't know what is happening. So any person that we are going to take a decision to summons, that person will know prior. So that person will have an opportunity to run away from receiving those summons. Then what are we going to do? We're then going to drop the issue and says, no, the person has not been duly summoned because when we tried to deliver them, the gate was locked, the house was, doors were closed, so we could not find anybody to receive the summons. So we're afraid of going to court because the court will say, yeah, but nobody has signed to show that he or she has received those summons. So what are we going to do? So not to do anything, I think we will be setting a wrong precedence, not only for SCOPA, but for Parliament in general, that Parliament can invite a person to Parliament. If that person doesn't want to come, will just stay away and not come because he or she knows that there's nothing that we can do. We're going to issue summons, then the person will know prior and the person will run away. In fact, does not even have to run away, he or she will just sit in his house or her house and just lock the door and then lock the gate so that nobody can enter and deliver those summons. And then they know that because you can't do that, so then there's nothing else that you can do. You won't go to court, you won't open a criminal charge, there's nothing you can do. You see, so we have to, in my view, let's open a criminal charge. Let's lay a criminal charge against Mr. Collins Letswalo. On the matters that the Honourable Speaker is questioning us about, let's allow a competent court of law to deal with those matters. We are going to present our case and indicate all the steps that we have followed. Mr. Letswalo, he will also have an opportunity to present his case. It will then be the court of law that will make a determination. And then if the court says, no, we are wrong, then the court must then tell us how is Parliament going to deal with similar cases in future? Because this thing does not only affect SCOPA and Mr. Letswalo, but it affects the entire Parliament and other entities and departments and other people who in future will be invited to appear before Parliament. So Hence, the speaker saying a matter like this has never been tested in a court of law. I think this is a golden opportunity to allow this matter to be tested in a court of law. So the other option that Ms. Ibrahim spoke about, to say maybe we can start afresh and summons him again. I don't agree with that, because he's going to do the same. He is going to do the same because he's going to know that we're going to summon him. I believe that even now, perhaps he's watching us. Is watching this proceeding. So he's still going to run away. So it means if we're going to do that, we're not going to finish this inquiry. We're going to take another 2 months, 3 months, chasing Mr. Collins Litswalo. And then when are we going to finish? Because we'll have to finish this inquiry, submit a report to the House, and then after that, so that we can then proceed with other responsibility that we have to focus on as a committee. We know that we are a very busy committee. We've got a lot of responsibility, so we need to finish this matter. So to redo the process is not going to assist, because it's going to do the same. I'm saying this because Mr. Litswalo has been on television. I think we all saw him, and he said, "No, I'm not going to attend that thing. I'm not going to attend that kangaroo court." No, when they ask him about the summons, he says, "No. Those things, they were delivered in the wrong address. That's a postal address. No, I said they must give those things to my legal team. No, those things." So he demonstrated that he is well aware that he has been summoned, but he's not prepared to cooperate and he's not prepared to come. So he's still going to play the same game using the same rules. So it's not going to assist. I think we'll be wasting Parliament's time. So let's lay a criminal charge against him and allow a competent court of law to resolve this matter. Thank you very much, Chair.
Thank you very much, Honorable Skosana. Can I just ask Honorable Atkinson, I'd seen your hand come up and then it went down. One, but I've seen it. Honorable Skosana, I'll come to you because a hand had come up. I've noted you. I've noted the hands, so don't worry. I will give you a chance. Honorable Atkinson, I'd seen your hand come up and then you dropped it. I see what you've written on the inbox. I just want to be sure that you are deferring to your comments on the messenger, because I'd like people to express their opinion rather. Okay, Honorable Atkinson is not on anymore. Honorable Atkinson, can you hear me? Okay. Honorable Isaac, I also saw a comment from you on the inbox, in which, so both of you, you've said, Honorable Isaac said, fully support the suggestion from Honorable Beasley. Honorable Atkinson said, agree with Honorable Isaac. I just want to be sure that you can hear me, because I need to get you to confirm what you've said.
Chairperson, it's Isaac.
Yes.
Yes, I can hear you very clearly. I fully concur with the suggestion by Honorable Beasley, and I also support what Honorable Skosana has also just spoken as the last speaker. So I don't think I want to delve on the matter any further at this point in time. I think we have exhausted the discussion. Thank you, Chair.
All right, thank you very much. Let me deposit my own thoughts and say why. Firstly, I've noted the comments of the speaker. I don't think it is our job to second guess what the National Prosecuting Authority would do. Even when we've taken additional steps, which I will talk about just now, it is still up to the NPA whether they want to prosecute or not. That's the first point of decision. The second point of decision would be by the court in deciding whether to convict or not to convict. And those are the competent bodies that must make those suggestions. It can never be possible for us to sit here, however many steps we take, to say a conviction will be guaranteed. We will never, ever be in that position in any event, under any circumstances. It's always up to the NPA to decide to prosecute or not. and up to the court to decide whether or not to convict. That is the first thing. The second thing, my own consideration of my view, is that if the alternative is to make sure that someone stretches out their hand and receives a summons, as long as they refuse, even if you find them at a mall eventually, you will not be considered to have served the summons on them simply because they put their hands in their pocket and decided not to accept your summons. And when you placed it on the table, if they're sitting at a restaurant, they simply walk away. If you find them in their car, they simply lock the window and they lock the doors and simply do not accept the summons. That interpretation, in my view, is extremely narrow and frankly ridiculous. As Honorable Skosana said, the same person would simply lock their gate and lock their door and not answer it. So I want to remind members of what actually happened because it can be forgotten. Firstly, we sent a series of letters and we received a letter that said Andizi. If you recall, there was correspondence late into the night, and I think we only got correspondence back from Mr. Letswalo's lawyers after 11, saying the committee does not have the jurisdiction. He is not coming to the committee. He does not recognize it. It's a kangaroo court and so on. He said, I am not coming on a specific point of principle. What he did not do was to take steps, therefore, to stop the inquiry. And we cannot second guess the rest of the process that he chose not to take and say, out of fear that had he taken that step, he may have succeeded and therefore let us paralyze ourselves. I do not think we need to do that. I also wish to remind that I was on the same program as he, interviewed, I believe, by Clement Manyatel. He was aware of the summons. He referred to the summons. He said he is not coming for the same reasons that he advanced in the letter from his attorneys, that the committee has no jurisdiction. I also wish to remind our members, and members, you have this correspondence in your possession of some of what we said to that argument. He said it should go to the Portfolio Committee on Transport. If you recall, I had notified in terms of the rules, the Portfolio Committee on Transport. I had personally met with the portfolio chair of PCOT and members of the Portfolio Committee on Transport had at various times, including the chair, participated in the proceedings of the Standing Committee on Public Accounts. And therefore, any argument that said the PCOT was not involved in the proceedings would not be true. In any event, Parliament makes its own arrangements. And what we are required to do with these things is to notify the other committee, which we consistently do, as we've also seen with the briefings by the AG on municipalities or municipalities coming over to Parliament and so on. The Portfolio Committee on COCTA comes and joins us. So we had already written a letter to his attorneys to say we are advised and are satisfied that we are still within the rules and therefore we've got jurisdiction over the matter. When we wrote a letter seeking concurrence of the speaker, we placed the same matters. The letter was about 30 pages long with annexures, if I remember very well, in which we tabulated the steps that we had taken. And one of the things that the speaker had to consider was whether this inquiry, we had the jurisdiction to do this inquiry, and whether therefore the summons was adequately formulated. And she agreed that we had. So there was legal advice even at that point, not just to the committee, but to the speaker. And on that basis, the speaker then concurred with the summons. So we are dealing with someone who is aware of the summons. When you narrow what the speaker says a technical legal risk is that we have to have the summons and force Mr. Letswalo or any other witness in future to open their hand and accept the envelope. I have never in my life heard of such. If someone is aware that they are required in parliament or in court, they're expected to appear. And out of his interview with Mr. Clement Manyatela, in which I was a part and I watched myself, he clearly stated that he is aware of the summons, he's not coming. He even knew of the history of where we delivered. Now, let me talk about the specific steps taken so that we also can remember. The address that he had given to us, the house was unoccupied. We then took the additional step of going to the Road Accident Fund and asking for an alternate address. They gave us that address. The sheriff went there on more than one occasion and eventually affixed the summons to the gate so that whoever comes can see that there is summons. Now, it was not left on the floor, it was stuck on the gate by the sheriff. We then took additional steps. If you recall, the purpose of a summons is to make someone aware of the summons. It was sent to Mr. Litswalo by SMS. It was sent to Mr. Litswalo by WhatsApp. It was put out on Parliament's platforms, if you recall, social media platforms, so that in the event that he is also on those platforms, he may be aware. The only thing that did not occur is for us to send a private detective to locate him and eventually chase him and give him a letter in his hand. If that is the expectation that Parliament must do that, then I align myself with the view that we must let the NPA make the decision. The NPA may decide not to prosecute. That's a cross we have to bear. The final thing that I want to say, this is not just about ourselves. The precedent is very important. If we are serious about the authority and the standing of Parliament, and that up until now, generally, public servants in particular, when invited to come to Parliament, have voluntarily presented themselves, and even in instances where someone had not wanted to come to Parliament, they eventually come to Parliament without the need to lay a charge. If this committee does not proceed, we are paralyzing Parliament. That tomorrow, the next person who is called will simply say, Andizi. And you know what? You must chase me, and even when you find me, I will put my hands in my pocket and refuse to come. And there's nothing you can do about it. The implications for Parliament and for oversight are profound. And my view is that we must not do things like that. The Speaker has called this a technical legal risk. Let us let the NPA make the decision, because in any event, even if the Speaker had not said so, there is always a risk that the NPA would decline to prosecute. Our responsibility ends with the complaint that we lay with the police. Beyond that, there is nothing else that we can do except to cooperate with the police and to cooperate with the NPA in the event that the NPA then decides to proceed with the prosecution. It's not our job to second guess them at all, because we can never, it's not our job, don't have the power, and we can never be guaranteed. So I align myself with the view that says, let us lay a complaint in terms of the Powers and Privileges Act and let the NPA decide what they want to do following a full police investigation. So that is my view. Let me give Honorable Skosana, because your hand is up, and then we will just see how many members want to proceed and how many don't want to, and we will record accordingly. If the view is that we should not proceed, then we will talk about what to do next. But if the view is that we proceed, then that's what we do. Honorable Skosan.
Thank you, Chair. I guess I'm allowed, Chair, to make a reference. You know, hence we are saying we should not bring other matters, but I have to make reference. I mean, we cannot ignore what is happening around us as members of Parliament, and these things are happening in Parliament. We have here General Masemula being held responsible for a PMFA. The only DG of the department in this country. And this is the same government. We cannot divorce ourselves and say we are not entertaining that because we are only focused on SCOPA or matters only. Reference is very important, Chair. Hence, I made a reference about Palapala that, a president has been said that you can keep millions of rands in the sofas in this country. And if it's somebody else, then he has to be arrested. Hence, we see other people being arrested for keeping thousands of rands in their homes. But we have a president in this country who can keep money and can get away with murder. In fact, he's taking us for a review. Now, I'm saying to you, Chair, the Speaker as well has a legal advice. Obviously, whatever the letter he wrote to us is from the legal department. It's not from her as a person. Now, if we have to serve papers, in fact, Honorable Skosana said, it never happened. No, it has happened. I was served with papers. People said they've sent me an email. I could not get that email. They could not prove that I've got the email. They could not prove that I've got an email. If the law says you must serve a person or somebody in the house, an elder who's over 18 years, we can't change that. We can't change that. You can't change me in a flight that I'm boarding from Cape Town to Johannesburg. Then you will find me there. If the law says so be it. But we cannot as well second guess as if, it's a matter of life and death. There's no matter of life and death here. We've got as well most important issues in this country. As I was making references here, to say we should be as well be seen by the public, be fair, and not being, like people now are accusing us of many things to say, yeah, no, ref, we are chasing this person because white companies are, Discovery, and they are mentioning names, and they have got a right to say that, to speculate and being suspicious of us. Now, let the law take its own course. If we have to, the sheriff's job is not for us as MPs who must go and serve Mr. Litswalo. Hence we are saying that the NPA might decline, they might decide to prosecute. It's fine, it's their job. Let the sheriff do his job. Let the sheriff get hold of Mr. Litswalo, or where he can hand over the summons if that's what the law says. Why should we go an extra mile? Why should we go an extra mile? As if, we are targeting him. Hence I was saying earlier, it should not be like we are targeting people here. If the law says that he must appear before us, for whatever reason, he has not received this, let the law take its course. If the law says that the sheriff must serve summons, it's upon them to make sure that they serve the summons. It's not upon us. We have done our job. Why should we now get involved in all these matters to say, no, we have to go, if we find him in a restaurant or we find him somewhere in a bar or in a shavin or in a restaurant, no, let the sheriff do his job. And the speaker is correct. We might not see the things the same as committee members, but if we want to embarrass ourselves as well, it's okay. We will suffer collectively so. But I'm saying it should not be seen as a vigilance, this thing that we are chasing a person. We've done our job. Let the sheriff do his job. But we cannot accuse anyone to say he has received, or somebody. The sheriff is telling us, I put this letter, this summons in the gate, and he says I did not get them. But I don't think that for so long a sheriff is unable to locate a family man who's got kids and a home. I don't think. I think there's something extraordinary here, which we are not getting the truth here. But let's not be seen as us chasing a person. Because hence I was saying to you, I'm going to make a reference. Reference is there for everyone knows about it. 4 years down the line, we are still not yet finished. We might even go out of this administration without finishing. It is normal. It has happened. It should not be like it will be for the first time. So my view on this matter as Umkhonto Wesizwe Party is that we should not be seen as chasing a person. You know, it should not be seen, because this perception out there now will bother some of us to say we are part and parcel of this so-called what they call it, fight back or whatever. You know, that there are people who are behind the scene who are in fact controlling us as members of parliament. I thank you, Chair.
Thank you very much, Honorable Skosana. Honorable Mende.
Thank you, Chair. First and foremost, Chair, I disagree with us going to open a case as a committee. There's no such a thing as a committee resolution that stands for Parliament. A committee is a committee of Parliament. It's not standalone from Parliament. So anything that we do as a committee, we're doing it on behalf of Parliament, which the Speaker is the head of Parliament, and any resolution to do anything under the umbrella of Parliament should be sanctioned by the House or the Speaker in this case. Now, again, I'm going to say we need to be wary of our actions and not be found wanting and be called delinquents. Honorable Skosana has covered this fairly well, that there is a job to be done by the sheriff. And the last time, which both yourself, Chairperson, and Honorable Whip of the Committee, Skosana, is saying that the argument of the person involved is that I don't have your summons. So we're going to court to say, what are we saying to court? And the fact that we are already preparing ourselves to say, no, the NPA may allow prosecution or may nullly prosecute and say there are no prospects of successful prosecution on this matter, is exactly because we're not confident of the case we're making. And there is no case to make until such time that we are confident that summons were served. There was a time when the emails were not receiving outside emails and all of those things and everything else. Even if majority in this committee will agree with you and resolve, we are a committee of Parliament. We are not a committee that can take decisions into. That is why we have never taken a decision to take any CEO, DG, minister as a committee to court for all the fumbling that they are doing in the maladministration where PFMA and MFMA is concerned. Skosana says the head of police is in court for PFMA. We should have done that as COPA, and the attitude now we are assuming, it's a very beautiful attitude. If this is going to be an attitude, I think we need to also call all the reports, which we have failed to do, and have a resolution that we need to open cases so that we can take all of them to court. The CEOs and the ministers, executive authorities, accounting authorities, and accounting officials. They must be arrested. But we have never done that. Why? The resolution we must take must be debated in the House and must be adopted by majority. It's not our call. Hence, the Speaker says there may be a risk in a process of us taking it, but the Speaker knows very well. And this is why I was saying to Ms. Ibrahims, can the legal experts of Parliament start pulling up their socks? Because they always advise Parliament wrongly, and even today, you are advising Parliament wrongly. Committee cannot take a resolution to take anyone to court. It must be subjected to either to the Speaker or the House. We're not a committee of ourselves. We're the committee of the House. We are established to do the work of Parliament because Parliament as a house cannot do all these things. Therefore, it then establish committees to do the work, and after doing that, bring the reports to the House. So the last thing is that if this becomes a resolution in the report that we will table in the House, and it becomes one of those resolutions of this committee, that because Letswalo didn't come to Parliament, one of our resolution to the House is the following. Let's not be delinquents, please, guys. And yeah, we cannot. Our emotions must come down, and we need to go back and understand who we are and our position in terms of Parliament. As individual members of Parliament, members of Parliament can go to any police station and open a case on anything they want to do and use the information which is public of Parliament. But as a committee, we can't. We can't even vote on that because it must be part and parcel of a report tabled to the House, and the House must decide what is the next step we take. Then if we are now isolating this matter, which is part of a bigger report, from the actual report, we might as well not take the report to the House. Why are we preparing a report to take to the House? Why are we not voting on it? It's because we realize and we know that we can't vote on that report until it goes to the House. So please, Chair, let's do things correctly. Thank you.
Thanks very much, Honorable Mende. Honorable Atkinson, I see your hand came up.
Yes, thank you, Chair. I'd just like to associate myself with your comments about our own legal team and Mrs. Ibrahim, just to say what an excellent job they have done for us throughout this entire process, and the completion of this report, the writing of the various different chapters, which have all been done with the utmost professionalism. And just to express my appreciation to her and to the legal team as well. And then secondly, I just want to come out in support of what you said. The fact of the situation is it's not a personal thing against a particular person. It's just that the people of South Africa are actually sick and tired of seeing people that seem to operate with impunity, that seem to be a certain class of people that believe that they're untouchable and that they can do what they want, that they can actually do the most egregious actions, basically almost destroyed a state institution, something like the Road Accident Fund, have taken it to a point where they've created a massive liability for the Republic. And we just want to say, oh, well, too bad, so sad, off you go, and not do anything at all about it. So most definitely not, Chair. I do support the fact that there should be legal action taken against them. I know there's no precedent for Parliament, but then we are creating precedent at the moment. And if this matter fails in the courts, then we will be able to see what went wrong, and Parliament will be able to make the necessary adjustments so that it won't fail again in the future. But the fact of the situation is, if we're going to have any teeth at all as a watchdog for Parliament, we can't just let this matter go by and leave it for other people to resolve and just basically let the guilty party off the hook. So I do support your recommendations here. Thank you.
Thanks, Honorable Atkinson. So I am going to just ask us to vote eventually, because we can also discuss this until 6 p.m. and the fundamental question, I'm coming to you, Honorable Isaac, the fundamental question is whether we're going to lay a criminal complaint through the Secretary's office or not. That's what it comes down to, and we have to get to a point of decision. Honorable Isaac.
Thank you, Chair. Chair, look, I say this with due respect, colleagues in the committee. Lots has been ventilated now regarding this issue. We've had the legal team's opinion. I must ask, and I say with due respect, if it is not our call to make a decision on whether we go ahead with this matter, if it is not our call, as has been ventilated by the previous speaker, then whose call is it? I mean, again, with due respect, I get the impression, that Mr. Letswalo is being protected by perhaps certain individuals or certain parties for whatever reasons that might be. That I don't think is the subject for discussion at this point in time. But to suggest that, or to make a comment and to suggest that we are delinquents, is not acceptable to me personally. I want to say, Chairperson, again, I've heard the various discussions. I have my own opinions. I personally think we have, again, exhausted this very discussion. We've been through lots. I want to urge you, Chairperson, let's move on. If we need to vote on this, then let us vote on this. We need to really bring this matter to a finality, because it is our decision as the committee to, at the end of the day, make the decision based on the quality advice that we have received from the legal team, which I'm very grateful for. So those are my comments for now. Thank you, Chair.
All right, thank you very much, Honorable Isab. Honorable Skosana, I'm going to a vote. Unless you're bringing up something new, because we have to make a decision. Otherwise, all of us can keep.
It's fine, Chair. I understand you that there's a rush for the vote now, but if you've given all these other two gentlemen, I think you must give me my last shot as well to say.
But everybody else has spoken once, Honorable Skosana.
Not really, Chair. I mean, I can tell you how many times the last speaker has spoken. You might have forgotten because we are chairing. But be that as it may, Chair, the issue which Honorable Mente was saying, that we must bring as well, and for him to say we are no one who's protecting anyone here. We are saying if we are not protecting anyone, we must bring all these other head of institution to come back, and let's open cases against them as well. Because we've dealt with matters where there's almost the same issues which we are accusing Letswalo. He's not the
haven't been subpoenaed.
I'm not talking about.
Please don't interrupt, Honorable Skosana.
Yeah, hence I'm saying people are invested, Chair, in this matter. Hence, when Dr. Somebody who was accusing us one day there, that we don't have any investment in this matter. We must treat everyone the same. I'm saying, even if it's the subpoena you're talking about, there's a sheriff who must serve this person with a summons. Now I'm saying, I'm supporting Honorable Mente to say all these other people we deal with here, they must come back, they must account, we must open cases against them as well. Because we know that public funds have been misused. Wasteful expenditure, we know that. We're dealing with this matter at Scopa daily. It should not be only one department ref only. As I was making an example that one person was targeted, that was General Masemula. I'm not missing my word on that. The only person in this country, the DG, who's in court for PMFA. We want to do the same here at Scopa. We can vote, but I can tell you now, Chair, we are not going to be part of that. Of saying that if we are not, I mean, the question is, if we take this thing to Parliament, let other, Parliament decide on this matter. What's wrong with that? What's wrong with that? Let's refer this matter back to Parliament. Let them tell us whether we are doing the right thing as well. No, not the NPA. We are members of Parliament. We are lawmakers. And I'm saying it should not be seen as that we are targeting a person, like what happened to General Masemula. How many DG came in here? How many institutions have, I'm not talking about being summoned. I'm just talking about people who we as committee members, we feel they've transgressed the law of the misused public funds. He's not the only person who appeared before us. No. No, even if you are being accused, now to say no, it's like you're protecting. No, if there's protection, then we must go to our parliamentary authorization. There, you'll know who is being protected there. But the same members who will say no, this one, this no. Chair, let's be honest, let's be fair to everyone. You can go to vote, it's fine, Chair, but I'm just saying, I'm raising this, that it should not be seen that all of us, we are part of the pack of hyenas who wants to target people. I'm not part of people who are targeting people. You know, if we have to have the people responsible, it should be across the board. And it's the right thing for us to do that. Let's have everyone accountable, but we should not pick and choose. Thank you, Chair.
Thank you very much. Look, on the target thing, I can't speak for other committees. I do not recall in my time in Parliament where someone has refused to come to Scopa. This is the only time. And I think if there was a case to be made, I think pointing to someone else who didn't come to Scopa and we took no action, but in this case we did, then sure. But this is the only summons I recall that Scopa has issued, and we have not given anyone a free pass. Honorable Madlala, you will be the last. We have to now bring this to a conclusion so that we know how we're moving forward. Otherwise, we'll discuss it the whole day.
Thank you, Chair, and greetings to members of the committee. You would forgive me if I happen to be repetitive. I recently joined because I am also in the conference, as I had indicated. But I want to echo some of the sentiments that the latter speaker, Honorable Skosana, just said. My understanding was that, and it's subject to correction, and if it has already been dealt with again, you would forgive me, was that in terms of the prescript or the regulations around the summons serving, there is no provision for any other methodology except to serve to a person or an adult found at a place of residence of a person. And my also understanding was that unfortunately, we could not locate Mr. Letwalo at the premises or the last known address. And as a result, we were not able to comply with both of these provisions. And we did serve on email. We were aware that he knew that there were summons because he spoke about them on media and all of that. But legally, if we did not end up, complying with those provisions, I also do not think we have a case. I am one person who believes that we should set a very strong message around disobeying the Parliament and its committees. But in a manner in which we do it, I want to also think and believe that we should be meticulous. We should follow due process and not jump the gun and subject ourselves to some embarrassment or legal embarrassment later on when we are legislatures. So I hear that there's a voting issue. I did not know that this matter was going to be voted on, but I want to state my view, which is a view that I share with the Honorable Skosana who was speaking now, that it may not be appropriate for us to vote to go ahead and test a provision of the law which we have not been able to comply with, and we know that we have not complied with. That is if there was no second attempt where an adult person signed for the summons, or he himself, or at least he was found and refused to sign. So I want to just recommend that we really don't push as if it's a personal issue. We have nothing personal, but we must set the record straight about the importance of respecting Parliament, and we must be very firm. And if this must be a case study for all other committees and everyone, and it must be the first one, let it be so. However, let us, remove the irritation that I at times feel when we feel undermined. And I think it's only human nature, but let's be professional about it. And let's ensure that we get to the best possible outcome in the interest of both democracy and accountability. Let me pause there, Chair. That is my view on the matter. Thank you.
All right. No, thanks very much, Honorable Madlala, and thanks for joining us from abroad and just taking the trouble to come here. So, honorable members, the debate is really about us convincing one another. of one or other position. So I think given that everybody has had an opportunity to state their view, the question now before the committee is whether we decide to go ahead or not. So I will guide as follows. So I will just ask each member to express specifically an opinion on whether we proceed or not. Once again, I don't want to assume the tally. Keeping then in proportion, so where there is the full committee representation and an alternate present, then the alternate obviously does not get to vote, and therefore so that we don't end up with a higher number of committee members inadvertently, as we would. So I am now going to just ask the members to say whether it is yes, we proceed with laying a criminal charge, or no, we don't. And then this will be noted in our minutes, and then it will be noted in our report. If we can now do that, I will simply go according to what I said.
Before you proceed on that one, when you say we, in other words, we are going to be respondent as well. If the committee opens the case, are we going to be, all the members are going to be the applicants? I'm sorry, not respondent. The applicants.
No, so let me ask Ms. Ibrahim to explain. So this is not a civil matter. This is a criminal matter. In court, it will not be Parliament versus Mr. Litswalo. It will be the state versus Mr. Litswalo. Parliament's role ends with the statement made to the police. The police may take further information, may request further information either from the Parliament Secretary or choose to talk to individual members. It's really up to them. We have no control over that process, number one. Number two, once the docket has been completed, it would then go to, this is the general process, it would then go to the NPA for a decision on whether they want to prosecute or not. Again, Parliament, it's not Parliament's decision at all. So we would not be joined in the action. In the event that the matter proceeds to court proceedings, it would then be the NPA representing the state rather than representing Parliament. However, for the removal of doubt, let me just ask Ms. Ibrahim if I've said anything incorrectly here or not.
Chair, you have summed it up correctly. The matter will be between the state and the person accused of contravening the law.
Yeah. So in other words, Chair, just to understand this thing very well, it's not us who are opening a case against Mr. Litswalo. Am I right? You are not the applicant in this matter. That should be clear.
So it would be the secretary to Parliament. That is what the Speaker has said at the bottom of her letter. If you can read the last paragraph, it would be the secretary to Parliament who then does the task. It's not me or any of the members.
No, it's fine. Say if that's the case, because I wanted clarity on that to say, if I'm an applicant, I don't want to be an applicant in something which I've been warned about. To say we might find ourselves, might happen. So I'm just saying that I wanted that clarity only. Thank you, Chair.
All right. Thank you very much. Okay, I don't want to make any assumptions, colleagues. I am just going to ask members to express themselves, and may I just ask the Secretariat to just keep tally of how many yeses and how many noes we've got. A yes is we proceed, no is we do not proceed with laying a criminal charge. Honorable Neil May.
Yes, Chair.
Okay. Honorable Maduna.
Proceed.
Thank you. Honorable Maduna, you haven't said anything, but I'm going to have to ask you because you are here.
No, thanks, Chair. Yes, we must proceed, Chair.
Thank you, Honorable Duna. Honorable Skosana G.
Yes, Chair. Let's proceed.
Thank you, Honorable Atkinson.
Yes, Chair, we will proceed.
Honorable Bila, you also hadn't said anything, but I see you are here.
Yes, Chair. I
Thank you.
support that we proceed.
Thank you, Honorable Mende.
No, Chair, I don't support.
Thanks, Honorable Mende. Honorable Isaac.
Yes, Chair, in full concurrence, we proceed.
Thank you. Honorable Kubega.
Hi, Chair. Given the stated issues before with issuance of the summons being incorrect, I vote no, Chair.
All right. Thank you very much. Can I take guidance from you, because there are 3 of you from MKP? So who's going to vote?
Chair, it will be myself and Honorable Madlala, Chair. Honorable
All right.
Skosana is our alternate.
Thank you very much, Honorable Kubega. Honorable Beasley.
It's a yes for me for proceeding, Chair. Thank you.
Thank you very much, Honorable Madlala.
It's a no, Chair.
Thank you very much. It's a yes from me. Thank you very much, honorable members. CEO, are you able to then give us the result?
Same as impeachment, Chair. You've won.
Okay. Now the secretariat is quiet now, which worries me.
Already helped you, Chair. You are the majority, like in the impeachment, Chair. Same thing. Don't worry.
No, that is fine. So the
Good morning, Chairperson.
Yes.
Morning, honorable members. Chairperson, the results from the proceedings is that 8 members voted yes to proceed with laying the charges, and 3 members voted no, Chairperson.
All right. No, thank you very much, Mr. Bowman. So, colleagues, that is the decision by vote. In the minutes to this meeting, all the views will be duly recorded, and also when we process the report, similarly with the objections and the reasons given for the objections as well. So, thank you very much, honorable members, for the discussion.
Chair, before you close, it looks like
yes.
we are closing, Chair. My
yes.
last parting shot, Chair, please, let's recall all these other HODs to come back here. Those who have done, who's transgressed, who have been found wanting in terms of public funds. We need to do that. Thank you, Chair.
All right. No, thanks very much, Honorable Skosan. Honorable Atkinson.
Yeah, I wonder if we just need to explain to Honorable Skosana that none of them have been subpoenaed, and that's why they're not facing illegal action, basically. So yeah, you're not comparing apples with apples. It's actually just a pointless comment, quite frankly.
Okay, members, can I just ask that we try and keep the temperatures moderate. Thanks very much, honorable members, for your participation since this morning in both sections. So on the okay, Honorable Madlala.
Thank you, Chair. And my apologies. I know that you are summing up.
Yes.
And I also believe that you've got it right. But just to add to your caution of trying to lower the emotions aspect, I think it's important that the honorable member who just spoke to correct Skosana is cautioned. I think it's becoming perpetual that his agitation or his irritation with Honorable Skosana cannot be held back, and with other committee members. It happened last time around the issue of Winnie Mandela, brought by Honorable Mente. It happens frequently now. that there's an interjection that seeks to undermine the intelligence of other members, and we don't want to degenerate. I just wanted to add that to say we've been operating very well for the past 2 years. Let's keep that spirit, regardless of our feelings. Thank you.
All right, thanks very much, Honorable Lala. I mean, I endorse the sentiment that we just try and keep the decorum between us on an even keel, so that we are able to have relations that enable us to do our job as a committee. So, honorable members, on that note, I was saying that we will process the comments. So when everything is consolidated, there will be two versions. One that reflects the changes, and another version then which would be the final version, which members will have an opportunity to see and before we vote on the report. So thank you very much. We are adjourned.
Thank you for keeping your emotions in check also, Chair. Well done.
Honorable Isaac, I'm gonna get you.
Thank you, Chair.
Thank you, Chair.
No, thanks, Chair.
Thank
And also,
you.
Mr. Isak, for always making us smile. Thanks.
Yeah, he wants to be in the
Thank
bad
you.
books.
Thank you.
Thanks, Chair.
Thank you.